Good morning, everyone. We'll call this meeting of the House Judiciary Committee to order, and we'll begin by pledging our allegiance to the flag. And Representative Horrigan, would you lead us today?
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Ahead of the game.
Thank you. Mr. Clerk, would you mind calling the roll?
Representative Gordon.
Here.
Representative McLean.
Here.
Representative Sylvia. Here. Representative Welper is here. Representative Alexander is not. Representative Green is not. Representative Nodder. Here. Representative Murner is not. Representative Kelly is not. Representative Trottier is not. Representative Smith. Here. Oh, I'm sorry, Representative Andrus. Representative Smith is here. Representative Birch is not. Representative Horrigan. Representative DiLorenzo. Representative Chase is not. Representative Kenny is not. Representative Langley is not. Representative Macbeth is not. Oh, Representative Langley is. And Representative Simpson. Representative Simpson. Good morning. He is. So let's see, Langley, yes. Take out the no. Representative Chase just walked in the door. Okay. Representative Page, I never called his name, but he's not here. No, I have.
Good morning, everyone. Our first item of business this morning is a hearing. It's a hearing on Senate Bill 375 relative to requirements for charitable organizations. The prime sponsor of that bill being Senator Gannon. And Senator Gannon, good morning. Would you like to introduce your bill?
I would. Thank you, Representative Gordon. Thanks for having me. I always love being over on this side of the wall because I learned there's 20 of you, usually in most committees, and there's only 5 of us. So you get a much broader view of everything. It's a good thing. I am Senator William Gannon. I represent District 23, and we call it the wine country now so if you're traveling of New Hampshire, we are surrounded by Labelle's, Zorvino's, Flag Hill Winery. So if you ever have a free weekend, you could do a nice wine tour. And that doesn't mean you have to leave out our lovely published establishments either. So come see my beautiful Lake District of New Hampshire, and be glad to see you, especially if I get a cheaper gas tax, Representative Smith. Anyways, but I'm here today to introduce the Charity Protection Act. So what the idea is, you asked me, Representative Smith, so I'll start with your question and see if I can help you. Representatives of the charitable foundations came to me and said, all across the country, we're getting overregulated. We have no problem, especially with the Secretary of State or the Charitable Trust Division. We're fine with the regulations they have, but around the country, we're getting onerously burdened by too much paperwork. And it's requiring more staff, diverting more attention. And it's not a problem with what they have on file. It's just because certain states, especially all around the country, are now saying, we want more, we want more. And so it's a never-ending battle, especially for some with certain charities. There seems to be certain charities that certain states are going against. And so we don't want that to happen in New Hampshire. And again, in New Hampshire, everything's running fine. They want to be regulated by the Charitable Trust Division. They don't mind the paperwork. And again, however, all around the country, they're vetted, which are becoming burdensome on these charities. And their primary task is helping us with the people most in need. We want as much of their resources going to the people of New Hampshire and helping the people who need our aid, and not going to unduly burdensome tasks of paperwork. And that's why I passed when it was presented to me that way. It seemed like a relatively straightforward bill, and I welcome any questions. There are experts who are going to testify who I'm more of a jack of all trades who knows a little bit about a lot of bills in the Senate. But I will try to answer any questions, especially yours, Representative Smith.
Are there questions for the senator? Representative Smith.
Thank you, Mr. Chairman. Thank you for taking my questions.
Thanks for
I
having me.
listened carefully to what you said, and you talked about all kinds of agencies in other states doing draconian things to charitable agencies. But this bill prohibits New Hampshire state agencies and officials from imposing filing or reporting requirements. It says nothing about what other states are doing. Can you clarify that for me?
I think I can. So the problem is in New Hampshire, where things are relatively fine now, we do not, other states have been overly burdensome on many charities throughout the country. We don't want, we're going to head that off here. We're happy with the requirements they're asking for now. Under a different administration, we just wanted it to be at a level playing field, that they're not going to all of a sudden say more, so they have to hire staff to do that. It's just a preventative measure.
Representative McLean.
Thank you, Mr. Chairman. Thank you for taking my question. These other states that are throwing on all these additional regulations, what's the driver behind that in those other states? What concerns are kind of pushing that, and are we not seeing those concerns in New Hampshire? So I'm just trying to understand.
We
what
haven't
the
as
outside
of yet.
drivers are.
It's political concerns towards certain groups, certain charities that are maybe not politically in favor. Be it you could either side of like a life issue. They may be pro-life, they may be anti, and they may be tougher on one group than another group. And it's just that's just one, could be one area. And we want everyone on a level playing field in New Hampshire, which we feel they are. And we think this is just going to set parameters and keep it the way it is.
Other questions? Representative Horgan, did you have a question?
Yes, there was, and of course we've had one of the groups that sent us an email opposing this was a group that sends us emails on many other political issues, and which is in fact state director is the former chief of staff for a former Republican Speaker of the House, so we all know who it is, and I don't want to attack him. He's within his rights doing what he's doing, but are you trying to prevent us from doing anything about, and they're both on the left and the right and everywhere in between, these groups that are in fact political advocacy groups, but for various reasons, mostly taxes and privacy, choose to structure themselves as 501c3s, even though they're in many cases quite political. So
I don't know if the question was, are we protecting more the left or the right? No, it's, we want them all treated the same. I'm sorry. I misunderstood your question then.
yeah, but do we,
Want to follow up?
is there some extent, do we want, regardless of what side their advocacy is on, do we have does the state have any interest in perhaps encouraging groups like that to be political to be something other, claim to be something other than a non-political, tax-free charity?
I think you're getting into the area of politics, and I'm not gonna.
Okay. Are there other questions? Seeing none.
Thank you very
Senator.
much. Have a great day.
You too. Senator Khan. Actually, this is rare. We have two senators today. This is.
I guarantee there are three over there right now. And Senator Gannon and I will join them very shortly because we've got a lot of bills that came over recently. So, Mr. Chairman, I'm Jay Kahn, State Senator from Keene, representing 15 of 23 towns in Cheshire County. So I am here in support of Senate Bill 375, excuse me. I'll just convey a short story, and Attorney Donovan will correct it once I'm done. But I don't think a year ago you saw a bill that I'd introduced regarding the uh, the floor at which a financial audit would be required of charitable organizations. Um, at the time, I was working with the not-for-profits organizations within the state to try to see if $1 million level, and this is what's in the end of the bill in section 3, if $1 million level is the right level still after the last time that this was updated, which I think was in 2004, but Attorney Donovan has the right figures on that. 2004? Anyway, the conversation with the organizations was, do we lift the level from 1 million to anywhere up to $5 million? There are about 700 organizations that, actually no, it's around 450 organizations that have annual revenues and expenses at $1 million. And there are about 120 of those that have revenues between $1 million and $2 million. So the proposal here to raise it to $2 million would be the first raising of that level since 2004. It covers about 150 not-for-profits that then would not be doing financial audits. They would still be submitting their 990 forms, like all not-for-profits do to the Division of Charitable Trusts. And the ability to continue to do audits would rest with the organization. At that $2 million level, it becomes required on an annual basis. So here's the difference that this makes, as has been explained to me by the $1 million organizations. And it's that they're spending about $15,000 a year on the preparation of the comprehensive audit. And that's a significant amount of the opportunity money that they have for annual awards for purpose of the organization. The higher you go in annual revenues, the smaller $15,000 becomes, but it's a flat amount. So this effort to raise this is something that both the financial auditing folks, which is the accounting organization in the state, and the not-for-profit organization in the state, both were in favor of lifting this. Last year we proposed $3 million. In further conversation with Attorney Donovan, some level it could be raised and still be competitive with the other 50 states in their policies. He just felt that if we tried to raise it to $3 million, it was beyond where we should be lifting it. So hopefully this amendment this year is amenable to the legislature, and we can proceed to relieve that financial burden from the required filings by not-for-profit organizations at $1 million to $2 million.
Representative Wolper, do you have a question?
I do, Mr. Chairman. Thank you, and thank you for taking my question. You spoke about the 120, I believe it was, you said, organizations that were between 1 and 2 million that would be exempted from auditing by this bill. And I thought you said it cost them about $15 million a year for the
15,000.
audits, but then you said
15,000.
15,000 and some are you talking about 15,000 each or $15 million altogether?
No,
Or
it's $15,000. If I said that incorrectly, I apologize. $15,000 is
that's each?
their audit per organization.
Thank you.
Representative Smith.
Thank you, Mr. Chair. Senator Khan, you addressed Section 3 of this bill, changing from 1 million to 2 million, but you said nothing about the other parts of the bill. Do you have anything to share with us about the other parts of the bill?
I don't.
Thank-
Obviously, I voted in favor of the bill.
Thank you.
Other questions? Representative Sylvia.
Thank you, Mr. Chair, and thank you for taking my question. For the organizations that are below whatever minimum is, what is the standard practice for their finances and without an audit, or are they doing a more simple audit? Do you know what the general practice is?
I think it varies because we're talking about such a broad range of organizations, $50,000 up to $1 million. They all comply with the 990 forms. So if you're familiar with those, it's a statement of financial position with revenues and expenses, cash, and the primary expenses of the organization, including personnel. Yeah, I mean that's, and so what the auditors just don't feel like they are adding that much value. I'll leave that actually to Mr. Donovan to explain, but they thought that this is a requirement that could be relaxed to organizations in this $1 million to $2 million. Sorry. Thank you.
Other questions? Yes, Representative Langley.
Thank you, Mr. Chair. Good morning, Senator. Can you help me understand how this legislation will impact upon the requirements of becoming a 501c3, or if it has any impact on that?
On the application process, no, I don't believe so.
But the requirements once you've become a 501c3.
Well, yes, as I understand, you're wondering, will this affect 501c3 not-for-profits?
Correct.
Yes.
In terms of auditing follow-up,
Yes,
Mr.
they
Chair?
would. They'll again. They are required to complete a financial position, statements of financial position in the 990 forms, federal 990s. Those will not be audited for that small group that sits between $1 million and $2 million of revenue a year.
Thank you.
Representative Di Lorenzo.
Thank you, Mr. Chair, and thank you for taking my question, Senator. You mentioned the word audit, and could you explain who would be the entity that would be doing the auditing? Thank you.
Well, boy, trying to remember the three that are the primary ones, but Baker Newman Noyes is one. Just for an instance, they're all AICPA recognized organizations.
Yep, you can follow up.
So it would be an outside auditing firm, correct?
Yes.
Okay, thank you.
Probably from within the state.
All right, thank you.
Yes.
Representative Chase.
Thank you, Mr. Chair, and thank you for taking my question. I would like you to repeat to me, if you would, the organizations you were saying that the nonprofits between a certain amount of money will not be audited. What was that? What was that amount?
But this is raising that auditing
Yeah.
cap or the floor actually,
Right.
from 1 million to $2 million.
Correct, but you had just before Senator De Lorenzo asked, you said something about this will affect the 501Cs, the 990 still have to be filled out, but will not be audited. And you said organizations between, and you gave a certain amount of money. It was way under the million. So the little guys. You
The 50 million, anything that's below the floor now,
Okay.
isn't,
Oh, you don't. You
they,
don't.
they do the Form 990s on an annual
And there's-
basis.
Thank you.
Yes, and Mr. Donovan maintains those. I've been on some not-for-profit boards. I know the filing date and how they follow up with the organizations if you fail to file, and he does a good job.
Other questions? Yes, Representative Andrus.
Thank you, Mr. Chair, and thank you, Senator, to taking my question. My question is, if this was changed to $2 million and there wouldn't be an audit, anything under it, would it be possible to make a change and do random audits every year, a small amount, and then that just keeps everybody's on their toes? Thank you.
You know, I asked that question of the auditors, and they said that really wouldn't be of much value. They come in and do that on an organization's request, but it's more, it's a lot of work for them to not have had the annual relationship with a company or with the not-for-profit. And that's the way they reported it. They said it seemed logical to me as well, but they said that the amount of startup to do that, they'd be overcharging for that initial every 3-5 year kind of thing.
Do you know of any charitable organizations that have asked for the change?
Yes, they have approached me, and once into it, it became clear, and we've had the benefit in testimony a year ago from people that it's time. It's time to come back and take a look at what we did 2004 in establishing the level and considering what an appropriate level today would be. And I yield to Attorney Donovan. He's a good judge of what he does, and if he's amenable to a $2 million cap, it will help a number of organizations that I'm familiar with.
Thank you. Representative Smith.
Thank you, Mr. Chair. Senator, I don't know if it's you or Mr. Donovan who would be best to answer. I wonder if there's a need to clarify when we use the word audit. I think we're talking about two different things. On the one hand, we're talking about a large agency, not-for-profit agency, charitable agency, being required as part of its own due diligence to hire an outside auditor to come in and verify the accuracy of their books. That's entirely separate from the work that charitable trusts would do in making sure, representing the interests of the state, not the agency, making sure that all charitable operations in the state are reviewed. For example, I'm the treasurer of the Durham Historic Association, and at $44,000 a year, I have to fill out a form and file it, and in due course, charitable trusts make sure that we're doing what we should do. That's entirely separate from what we're talking about here, so that it's not that those organizations up to 1 million or 2 million or whatever would not be within the responsibility of charitable trusts. It's just that they're not going to have to hire an expensive accounting firm to do an external audit. Am I correct in that?
I wish I would have added that to my testimony if I failed. So,
Thank you.
it's an excellent explanation. Thank you very much.
Are there any other questions or explanations? Okay, thank you very much for your testimony today,
Thank you,
Senator.
Chairman Gordon.
And Attorney Donovan.
Thank you, Mr. Chairman, members of the committee. My name is Tom Donovan. I'm the Director of Charitable Trusts at the Attorney General's Office. We have responsibility for oversight of the 11,000 charitable organizations that do important work every day in our state, everything from our large hospitals and private colleges down to local little leagues and historical societies and everything in between. As is common, we do not take a position on SB 375. I can report that there were, we had some concerns about the language as introduced in the Senate, and there were changes made, and we feel comfortable with the amendments that were made. And then Senator Kahn's amendment added Section 3 about changing the floor for audits. So I'd be happy to answer any questions that members may have about this. We're going to be back this afternoon on another bill, SB 302, which also relates to charities, and we are opposing that bill. I can't be there. My Assistant Director, Diane Quinlan, will be there for that, but that's a different bill.
Questions for Attorney Donovan? I guess I had a question just with regard to the increase from $1 million to $2 million. Is that something that is appropriate change in this day and age? Is it?
It reflects inflation to sure. And we look at what other states do, and it's sort of on the high side for a floor, but we feel comfortable with it. We're sensitive to the fact that it's an expense because the organizations do have to hire an outside CPA firm, and that does cost money. Senator Kahn mentioned $15,000 a year. Some firms would charge that. That's on, I think, on the high side. Some would charge less. It's just like lawyers or other providers. They have different, some are more expensive than others, but it certainly is an expense, and we're sensitive to that.
And if I could just follow up on that, it seems that it would be typical for organizations to be audited in some way. Do you believe as a result of making this change that there are organizations that will decide to no longer be audited, or would they typically be audited?
That's a good question. Some organizations have other requirements to be audited independent of ours. For instance, I believe some organizations that may have a contract with DHHS or a federal agency, they may have a requirement as a term of that grant or contract to have an audit. So that would not be affected by this. But I do believe there will be some organizations. Senator Kahn mentioned a constituent of his who has revenue between $1 million and $2 million, and likely will cease having an audit.
Other questions? I guess I do have another question, if I could, and that's with regard to the first part of the bill. And basically, the testimony that I've heard with regard to that is there's really no problem in New Hampshire as of right now, but this is sort of anticipatory, and that we don't want any type of problem. I guess the question is, and so the question that I have is it necessary to pass legislation if there's no immediate purpose for it?
So that's a judgment call. I can't comment on that.
Thank you. Representative Smith.
Mr. Chair, Mr. Donovan, let me um, follow up on the chair's question in a slightly different way. Have you, in your professional area of authority, recognized any problem that exists in the state of New Hampshire in how we manage filing and reporting requirements?
So, I think that our old forms needed work and we have changed them, particularly for smaller organizations. One of the charges that was placed on me when I got hired 7 years ago was to allow online filing to make it easier, and we've now implemented that. And I think that that helps. I think it's not so much what is being requested, but how inconvenient it is to get people to do that. And so we've been looking at ways to streamline it, so we get the information we need to do our job, but to do it in a way that's not unduly burdensome for the charities.
Thank you. May I follow up?
You may.
Are you saying that under current law, you have the authority to make sure that you can do the most appropriate job possible to monitor charitable trusts, including making changes in practices to conform with the changing world?
Yes, but the world of fundraising has changed in recent years because of online giving, which is a good thing. There's good GoFundMe and all sorts of other opportunities. And some of our statutes about fundraising were written before there was an internet. And so the laws we currently have were designed for a pre-internet era. So I think on my to-do list, and the to-do list of people in my position around the country, is to think about ways to address that, and that likely would have to happen by regulation. And the big thing would be disclosures to the public. Sometimes when people are giving through these platforms, they don't realize that maybe the money could be redirected to another organization, or it might take a month or 2 months for the charity to get the money. We recently had looked into Facebook because there was a charity that didn't get their money for a year. Well, it turns out there had been an issue with respect to bank account numbers and things like that. But we were concerned about that, and we think legislation could help with that.
Could I follow up just once more?
You may.
Thank you very much. So, do you anticipate then that the first part of this bill, which seems, if I'm reading it correctly, say we can't, whatever we're doing now is okay, but we can't make other changes? Do you see that as conceivably interfering with your ability to carry out all the work that you, in the incredibly fine tradition of charitable trusts, would want to do?
Let me answer it this way, Representative. If we were going to make a change propose to make a change with respect to online giving, we'd come to you and propose a bill.
Thank you.
And I guess if I could just, because you mentioned, well, there are some things that we might need to do. You referred to GoFundMe and the way monies are being used, particularly with regard to online, and you mentioned regulation. But if I read this correctly, you would not be able to do regulation in terms of administrative rules. You would actually have to come to the legislature and make statutory changes.
I think that's right.
Representative Di Lorenzo.
Thank you, Mr. Chair, and thank you for taking my question, Mr. Donovan. You know, as we were speaking about charities, thought about charitable gaming and wondering about, you know, regulating and auditing charitable gaming. What are your
Yeah,
thoughts on that?
so luckily, lottery takes care of the oversight of charitable gaming, not us. And they do have good oversight. And I know there have been situations where there's been abuse with charitable gaming. And we hear it, and we'll be informed about that. But they do a form of audit with respect to that portion of the money. So that's certainly an area of concern, but lottery's got a lot of eyes looking at that.
Representative Chase.
Thank you very much. And thank you for taking my question, Mr. Donovan. So just because I don't understand all of this and I want to, are you saying that all the online GoFundMes and these other fundraisers, do you actually have to look at these and make sure that they're legitimate, or how is this affecting the charitable trust?
Okay, so there are, and I'll try not to take too much time. There's big C, capital C charity and small c charity. The bulk of giving on GoFundMe, for instance, is, my name is John Smith and my wife needs help paying medical bills. That is small c charity. It's one person asking for help for an individual. That is not regulated by our office at all. Big C charity also happens on GoFundMe to a lesser extent, and that is where, let's say, the Red Cross is raising money and is using GoFundMe as one means to do so. That would be regulated by us. And a number of small, Red Cross isn't a good example. Maybe the historical society would be more likely to do a GoFundMe campaign. And we would have some concern to protect the charity and also the donor that things are going correctly. And it's not just GoFundMe, it's also Facebook, Amazon, Smile, PayPal. There are a lot of these online platforms, and we just have concerns that we don't want to discourage it, because it's a way for people to give money quickly, simply, and it's a way for charities to raise money, and we sure would prefer that in comparison with those annoying phone calls you get at home. And we're actually seeing there's less of that happening because so much of giving is moved online.
Just one follow-up.
Representative Chase.
Sorry, thank you. That was very clear. Thank you. I understand now. One other thing though is, what about like the Giving Tuesday and these other kickoffs, the 603s that we get now? Where did those fall?
So those are great opportunities, but those charities should all be registered with us. And what we find that New Hampshire Center for Nonprofits does, they give New Hampshire events every so often, and they have requirements, including that they be in good standing with our office. And so you'd be amazed how many charities that are not in good standing with us get their delayed reports in to us so they can be in good standing so they can participate. So those sorts of things we really encourage.
Any other questions? Yes, Representative Simpson.
Thank you, Mr. Chair. Thank you for taking my question. I am wondering, back to the changing the cap or the exemption from $1 million to $2 million. I was wondering, right now, how many questions, inquiries, investigations do you have, say, from donors asking about financial information about charities or organizations that are below the 1 million right now per year?
Yeah, we get a couple of calls a week from people asking about charities and, are they legit, et cetera. Then we post all of the charities on our website, and we either indicate whether they're in good standing or not in good standing. So I don't have, we can track that, but I don't have any information about that. But yeah, people do ask that, and it's publicly available information, so they can get the Form 990 if they ask for it. So we can give that to them.
Other questions? Seeing none, thanks for your testimony
Okay,
today.
thank you.
And we have Elizabeth, is it McGuigan? McGuigan? McGuigan.
Thank you, Chairman Gordon, and thank you, members of the committee, for the opportunity to speak to you today about Senate Bill 375. My name is Elizabeth McGuigan, and I'm Director of Policy for the Philanthropy Roundtable. Now, the Roundtable is a network of charitable donors working to foster excellence in philanthropy and to protect philanthropic freedom. Our more than 600 members include individual givers, family foundations, and community foundations located in New Hampshire and around the country. So New Hampshire is home to nearly 700 foundations that give out millions to charitable causes each year. New Hampshire's future will be brighter if it continues to foster a friendly environment for private charitable organizations to help meet the needs of its citizens, enrich its culture, and help solve pressing social challenges. So this bill, the Charity Protection Act, allows New Hampshire's philanthropic organizations to fulfill their missions without government overreach. The bill calls for any new requirements in 501c3 corporations to first be deliberated and approved by the legislature, excluding charitable trusts. Now, under New Hampshire statute, this protects private foundations and charitable organizations and ensures that the state's Attorney General still maintains full authority for regulations over charitable trusts, charitable sales promotions, and solicitations. This is a common sense reform that honors the transparency of the legislative process, as well as your roles as duly elected representatives. So this bill allows New Hampshire's charities to focus on advancing their missions rather than on complying with increased government mandates. By requiring that the state legislature approve any new regulations or reporting requirements on charitable organizations, this measure introduces transparency and accountability into the regulatory process. Now, this is a proactive, protective bill that we feel sends a signal to charities that New Hampshire will not overreach in the future and that it values the strength of its charitable sector. So why pass this bill if there's not currently a problem with regulatory overreach in New Hampshire? The short answer is, if overreach becomes a problem in New Hampshire, as we've seen in other states, under future officials, it will be too late to address through simple proactive legislation. Nationwide, charitable organizations are increasingly facing calls to disclose more details about operations, governance, and grant making that do not improve organizational effectiveness, but do increase operational and compliance costs. Some states require nonprofit corporations to complete forms with multiple agencies that often ask repetitive and sometimes invasive information. While there are no social benefits to these new regulations, they divert funding away from charitable giving and toward complying with red tape. So this bill aligns New Hampshire's governance of charitable corporations with existing state and federal law unless the legislature determines that it's necessary to enact changes. This reduces the potential for unelected officials to impose more stringent operating requirements, thereby increasing the operational and compliance costs on tax-exempt organizations. So we believe philanthropy can and should be a vital part of our communities. And we've all seen the good work that charitable organizations have done during the pandemic. And this bill will help to protect New Hampshire's charitable sector and send a proactive message to charities that New Hampshire is a pro-philanthropy state that values their contributions to local communities. Thank you for your consideration and time today. I'm happy to answer any questions. Bless you.
Any questions for Ms. McGuigan? I have to be honest, I've never heard of the Philanthropy Roundtable before. So could, just in terms of making it New Hampshire oriented, could you give us an example of who might your membership be in New Hampshire?
I'm not on the membership side, so I don't have specific names of our members in the state. But in general, we're private foundations, community foundations, and individual givers who care about advancing causes that matter to the communities.
Representative Smith?
Thank you. Thank you so much for coming today to share this with us. I'm looking at your statement, and I noticed there's no address or phone number or email. And if we want to follow up with you, could you tell us where you're based and how we get in touch with you?
Absolutely. I'd be happy to provide that information
Thank you.
to the committee. Thank you.
Representative Horgan, did you have a question?
I apologize. I missed the beginning of your presentation. And actually, the question was just asked was the first one that I had. But the second, 501c3s are often expanding their mission beyond, I think, what was originally envisioned. Many groups do what stays, just on the far, which isn't quite political advocacy, but very close to it. And also, like here in New Hampshire, something that's pervasive is we use them to administer all kinds of government programs, including, for example, a very large new educational voucher program. So how will this bill impact the state's ability to, first of all, keep track of 501c3s who are administering governmental programs for them, and also to make sure that they don't cross the line with political advocacy or other activities?
Sure. I would thank you for your question. I would say that there are a couple different aspects of the bill that I would point out. The first is that this law would not apply to state grants or to state contracts,
Yep.
as well as fraud investigations or general enforcement measures. So if there are charities that are working with the state, there is a need for transparency. If they're getting state contracts, that of course is not covered by this bill. To your second point about political advocacy, for example, I think that is a separate question, that if 501c3s in general are overstepping their stated missions, that is either something that should be investigated and enforced, which is allowed under this legislation, or it could be an avenue for further legislation to, on the state or even on the federal level, to say what is a 501c3 and what should they be allowed to do.
Right. Thanks.
Other questions? Seeing none, thank you for your testimony
Thank you.
today. And is there anyone else who'd like to testify on Senate Bill 375? Seeing none, we'll declare the hearing closed. I obviously misjudged how much time it would take for this hearing this morning, so we'll be in recess until 10:30. The next hearing will be held. Good morning again, everyone. We'll call the House Judiciary Committee back to order. Our next item of business is a hearing. It's a hearing on Senate Bill 296. This is a bill relative to complaint procedures in cases before the Commission for Human Rights. The primary sponsor of this bill is Senator French. I see that he's in attendance. And Senator French, would you like to introduce your bill?
Good morning, Mr. Chair, and to the committee. For the record, my name is Harold French. I am Senator from District 7, and I'm here to introduce Senate Bill 296. I'd like to remind you all that we are also meeting on the other side, listening to all the bills you sent us, so take that into consideration. Senate Bill 296 is a bill about fairness. It amends RSA 354A, so the complainant is the only entity that can remove a discrimination claim to court from the Human Rights Commission. Under current law, one's employer can force an employee to court after finding of probable cause of discrimination has been made by the Human Rights Commission. This makes the employee have to start the process over again from scratch. I feel, and many other people feel, the employee should be the only person to decide where to pursue their claim. This bill would not impact many claims, but for those it does, the impact would be invaluable, and I would appreciate this committee's support of this legislation. Thank you, Mr. Chair.
Are there questions for the senator?
Great committee. Great committee.
Yeah.
Yeah, I'll remember that when you come over.
Yeah. Remember that when you hear our bills.
Thank you very much.
Thank you, Senator. Dave Juve, who has asked for 1 minute.
Thank you, Mr. Chair, members of the Judiciary Committee. For the record, my name is Dave Juve. I am a Senior Vice President at the Business and Industry Association, which serves as New Hampshire Statewide Chamber of Commerce. For those, I know many of you are familiar with the BIA. For those of you who are not, we have approximately 400 employer members with over 90,000 New Hampshire employees. We are here in opposition to this bill today, and I thought it was interesting that Senator French described this as a bill grounded in fairness, because I would argue this bill is completely unfair and inappropriate for New Hampshire in that we are choosing through this legislation to only allow one side or one party access to the courts in a jury trial. That seems eminently unfair to me. And so I would urge you to, at best, kill this bill. But I would also recommend perhaps you might want to consider interim study, because I do think there are issues related to how discrimination cases get adjudicated in the state that are worth looking into to see if we can improve the process and make it fairer and faster for all parties. So, Mr. Chair, I don't know if I'm under a minute, but that concludes my testimony. I would say that there are several employment attorneys who are here who've also filled out pink cards, who have a lot of experience in this area. I'm happy to answer questions, but they may be more capable of answering than I.
Does anyone have any questions for Mr. Juve? I think you pretty much stayed within your minute.
Thank you, Mr. Chair.
Thank you very much. And we have Ani Malachi.
Good morning to the House Judiciary Committee. My name is Ani Malachi. I'm the Executive Director for the Human Rights Commission. I don't need a lot of time to speak, but wanted to just make sure everyone knew that I was here so that I could answer any questions that you might have this morning. Maybe it's better to have others provide testimony and then you call me back up, but it is up to the beautiful, smart minds that are in this room to determine what order you'd like to do this. I do have a handout, and I'll make sure that goes over to Representative Murner, and he can pass that around to everyone.
Well, are you, I guess if I could just ask, are you supportive of the legislation? What would be the consequence of passing the legislation if you could, since it's going to affect your organization?
Right. The commission is supportive of whatever the legislature decides to do. Our job is to follow the laws as so written and so decided. And so we don't take a position on this. We will do what we're told to do. We already do have hearings there. Potentially this could be more, but at this point it is indeterminable because it's not sure if respondents, if not allowed to remove, if they're going to settle cases more so than having hearings or removing them to court, or if they will stay with us and finish out the hearing process. There's no way to know that at this point. So it would really depend on what they would do in the future. And if they remain with us, then yes, we would need to have some staffing changes made. But those are some of those elements are things that we need anyway, just to allow us to continue to move through the caseload that we have.
Representative Chase.
Thank you, Mr. Chair, and thank you for taking my question. I'm just reading the summary of the hearing in the Senate, and it talks about your testimony, but it also says under the current law, one's employer can force an employee to court after finding probable cause and discrimination has been made by the HRC. What exactly does that mean, that they can force somebody to go?
That's a very good question, and thank you for that. I'm not sure about forcing. I know that respondents have an opportunity to remove a case after probable cause. So I think it depends on who's writing as to whether it's a force movement or removal.
Other questions? Representative McLean.
Thank you, Mr. Chair, and thank you for taking my question. So what drives people to go to the Human Rights Commission over going to the Superior Court in the first place? What's the difference that you see?
That's an excellent question. The statute. So statutorily, you are required to come to the Human Rights Commission if you have a charge of discrimination in the areas of employment, public accommodation, and housing, or with public education, which was added, K through 12 public education, that was added in 2019. So education has what's called a true choice of forum. You can come to the HRC or you can choose to take it to court. There are opportunities after certain steps that if either party would like to remove and go to court, they have the opportunity to do that. Customarily, if the complainant is removing or the charging party is removing, they are represented by counsel. With our process, you don't have to have counsel, regardless of what side of the table you're sitting on, whether you're the complainant or the respondent. So that if the law weren't there, maybe that's a driving force, but statutorily people have to come to the commission first to docket their charge. They can certainly, if they're a complainant, they can remove it after docketing and go on to court, and they don't have to continue through with our process.
Yep, follow up.
So, and you mentioned earlier in response to Representative Chase's question, I think that you didn't have the data, but I just wanted to be sure. Do you have any visibility in the amount of people at the end of the 180 days who are removing their case to the court of their own volition, or the respondents are moving? So do you have any feel for what the breakdown is of that?
Thank you for the follow-up. So the way this works is statutorily, the commission has 2 years to move through the totality of a case. And the way it's written, yes, 180 days you can remove, but usually what will happen is a respondent will typically remove after probable cause is found because that's when they are able to remove. However long that takes to get to the probable cause finding. So they're able to remove at that point. The complainant can remove at any point. So to begin the process, a complaint comes in the door, and it meets the legal standard of a charge. Parties are notified, and then after that, the respondent will respond to that charge. Once the case is assigned to an investigator, then the investigation takes place and there's a finding at the end of that, whether it's probable cause or no probable cause. If there's a no probable cause finding, everything is dismissed, the case is closed. However, there are appeal rights that the charging party has or the complainant has. If they don't agree with our finding, there are a couple of different options that they have at that point. If it's probable cause, then what happens in our process is it moves on to a conciliation, which for the non-lawyers is really, it's mediation just after probable cause finding. So there's another opportunity for both parties to come together and to talk about the charges and to determine if they can make a settlement at that point. If a settlement is not reached at the conciliation conference, then it turns into a pre-hearing conference, which means we start to look at dates on the calendar to be able to schedule the hearing. A hearing is scheduled, but between the pre-hearing meeting and the actual commencement of a hearing, the parties can still negotiate. They can still talk and potentially reach a settlement. And if they do, great. Then the parties will notify the commission, a settlement has been reached, and then as far as we're concerned, the case is closed.
Other questions? Representative DiLorenzo.
Thank you, Mr. Chair, and thank you, Ms. Malachi, for taking my questions. You know, I'm listening and looking at the timeline of how long it takes to get to a conclusion on a case or to end the case, and it sounds like some of the timelines are up to 2 years. Okay, may I follow up?
You may.
So when you have a worker, for example, who is in a workplace and they're being discriminated against for whatever reason, it seems to me, or do you think that's an emergency situation?
Thank you for the questions, Representative DiLorenzo. It depends on what the charge is. Ultimately, what happens is we have 5 investigators to investigate cases for the entire state. There were a few more prior to 2011, and in this upcoming budget cycle, like all state agencies, I'm asking for additional help. And so in order to not to overburden the investigators, you want to have them have a realistic caseload so that it's something they can actually touch the cases and move through them a bit more expeditiously. We recently went through our process, staff and management, and looked at areas where we could tighten timelines up. Report writing is one of those things so that we can move through the cases. I don't want to say quickly because that seems like you're cutting corners. No corners are cut. So, but timelines are tightened up, right? So where someone may have had months to send something in, it's several weeks. And since the finishing of that conversation with staff and coming up with a new system, or an updated system, I should say, recently the assistant director and I sat in on a conversation with the bar, the employment bar, or employment section of the bar, excuse me, and informed them of what that is going to look like, and you know that we're all here wanting the same things, that the cases move through quicker, but certainly not to the detriment of either party, because our job at the commission is to be neutral. We're fact finders, and to neutrally in a neutral format, listen to what's happened and make a neutral determination. So we're not favoring one party over the other. Certainly, if a person has lost a job, certainly that's important and traumatic. However, even in other areas, it's not something, because of the investigation that needs to take place, and it needs to be thorough. You need to investigate, you need to interview witnesses, you need to talk to the individual or anyone that witnessed it. You have to look through and request files to come from the respondent. And you also need to be able to schedule everything based on people's actual schedules. And we're able to do some things in a virtual manner, which is helpful for complainants who may have lost income and may not be able to, could live in a different place in the state and may not be able to travel to our office. So we're looking at different opportunities and ways to connect with people so that they have every opportunity available to let their voice be heard. Would it be great if things like this could be done in 2 weeks? Sure, but that's not a realistic timeline because of the steps that have to be taken, even in a condensed timeline, that have to be taken so that it's fair to both sides. The respondent needs to be able to answer any charge given as thoroughly as the complainant has made their allegations.
Thank you.
Other questions? Just in terms of my understanding, how many petitions or complaints do you receive in a typical year?
So let's see, looking at, and this is on the federal schedule, just looking at the employment ones, we have a work share agreement with the EEOC, who's our federal partner. So if we look at the federal fiscal year for 2021, I believe we had a total of 242 closed cases, and that's federal and state only. But we, and then that, of course, you're looking at not just ones that were filed. So I think for 2021, we had a total of 192 cases filed that year, but then we're pulling from the previous year to move those forward. So we could have anywhere from, you know, a slow month, I use air quotes there, could be 7 or 8 charges that come in that are docketed, but we could also have as many as 25 or so charges that come in that are docketed. There's not really a rhyme or reason. It's not necessarily, it's not always slower in the summer and busier in the winter. It just depends.
Representative McLean?
Thank you, Mr. Chair, and thanks for taking a follow-up question. I mean, I think it's very important that we want to preserve access to justice, you know, for everybody that's involved in a claim. Do you find that when people are having their claim removed to the Superior Court by the respondents, do you have any data of a high incidence because of the greater financial burdens of going to the Superior Court, that you're seeing in that event a lot of people just dropping their cases? Do you have any data of how many people, when that happens, actually go through the whole course of things? Or versus, okay, I'm in Superior Court now, I just don't have the resources to go forward. Do you have any data around that?
That's a really, really good question, and I appreciate that. Because the individual has removed their, well, because the case has been removed from the commission, we do not track it past there. So what I could tell you is, you know, how many have been removed by the respondent, if any, how many have been removed by the complainant. I can tell you how many cases settled. I can tell you potentially how many in a calendar year have just withdrawn, meaning they went somewhere else or they were finished. So our job is complete at that point. So I do not have any additional data or anecdotal data. No one is required to let us know what the outcome was. So I don't have anything past the responsibility of the commission.
Thank you.
Representative Langley.
Thank you, Mr. Chair, and thank you for taking my question. This is a follow-up to Representative DiLorenzo's question. Do you have any capacity to triage complaints as they come in, or, you know, decide at some level that something is so egregious that it bumps to the top of the list and gets immediate attention, or do they all sort of have equal attention on their way in the front door?
Great question. Thank you for that. So customarily what will happen is things have equal attention. However, if we realize that there's something that, wow, right? If a charge comes in, we have an amazing relationship with our client services representatives at the Department of Justice, and so we could have that conversation with them to determine if we could move, if it makes sense to move this one ahead. So the difficulty with that, it's on both sides, right? So the person, if it's an egregious situation, your heart and your sense of justice wants to move that to the top of the heap and move that through the process. However, the other side of that is the other people who are waiting in line who feel as though their claim is just as important and deserves just as much weight and care and adjudication and investigation. So that's a hard one. However, if there's something that's just so far out there, we'll have that conversation with the Department of Justice to determine, okay, if we do this, we also have to look at precedent. What precedent are we setting? And what does that look like? So that's a non-answer to your question, but that's kind of the best I can do for you this morning.
Thank you.
Thank you.
Representative DiLorenzo.
Thank you, Mr. Chair. And Ms. Malachi, just a question about the effect of the pandemic and if you noticed more complaints during the pandemic. Thank you.
Thank you for that question. We did not. So complaints slowed down some during the pandemic. We still had them, but they slowed down some. I don't have actual numbers in front of me, but I could certainly look for that and send it to you. Oh, okay. Thank you.
Other questions? Representative Simpson.
Thank you. I'd like to follow up on Representative McLean's question. You were saying that you do have the data for how many cases are removed by respondents and how many are removed by complainants. And I'd love to have that information if you could give that to us.
Yes, thank you for the question. I do
Great.
have a handout here, so I'll give that to you. And it's just looking at 2021, because 2020 is, the year that never happened. And so I think 2021 is a, sort of post-pandemic, but what those numbers look like. And so what I've done actually is taken our chart on how we schedule the hearing. And so the status of that particular case was whether it was settled, who it was removed by, and then below or in the case name information, it will say if the respondent, not the respondent, but specifically if the complainant is represented or unrepresented. So if you see pro se CP, then it just means that they're not represented. And of course, I would do that if there were any respondents in any of these that were unrepresented. In this particular situation, for 2021, there were not, but we do have times where there are respondents that are not represented by counsel and move through our entire process up to and including a hearing.
Great. Thank you.
You're welcome.
Representative DiLorenzo.
Thank you, Mr. Chair. Just one quick one. Are you an attorney?
I am not.
Okay, thank you.
Okay. Is that good or bad?
Well, you seem to be very, very well versed in your work, and I really appreciate it.
Well, I
Thank you.
appreciate that. Thank you very much. It's very nerve-wracking sitting here. You guys, there's a lot of questions. I'm always very nervous. You're all nice. I'm always nervous. It's like, what question will I ask? Will I know the answer?
Okay, other questions? You and I think you just answered my question, and the number of complainants who are pro se, and from what I gathered, there aren't very many who are self-represented. Is that true?
So for 2021, we had 26 hearings scheduled, and this is on the document that I will give you also. If you don't want to write it, you don't have to. But so we had 26 hearings scheduled. And we usually try to schedule 3 per month because, because some will settle, one may go ahead, someone is removed. So we just try to at least schedule 3 per month. Of the complainants that were represented by counsel, there were 18, which means that there were 8 that were unrepresented. and the total number of, well, all of the respondents were represented. The total number of cases of the 26 that settled were 11. There were 9 that were removed by respondent, and 1 case was withdrawn, and then we actually ended up with 1 case that we heard at the commission, which was a 2-day case.
So the largest majority were removed by the respondent? to-
Yes, there were no cases removed by complainant. So of the 26, 9 were removed by respondent.
And if it's common in the circuit court with small claims in particular, if people are self-represented and the case is worth more than $1,500, that respondents frequently ask to remove it to the Superior Court because it's more intimidating to people who are self-represented. Is that something that you would know of or experience in terms of those types of claims that you're dealing with?
Thank you very much, Chair Gordon, for the question. I would not, but if it's removed to court, the opportunity for the complainant to have additional fines and fees is more than with the commission. I'm not sure if that answers your question. I don't have any anecdotal data on that. I mean, we can suppose that may or may not be the case, but I don't have anything definitive to enlighten anyone on that topic.
Okay. And I guess if I could ask one more question, and so basically whether they remove or not, basically what you said is that's really for us to decide as a matter of policy as to what we should do. But I guess the question ultimately that I'd have is, what is the effect on the commission? Because I am already aware that, just as other people have implied at least, that it seems to take a long time to go through the Human Rights Commission. Typically, at least anecdotally, that's what I hear, that it's a long process and longer, and many people feel maybe longer than it should be. So what will be the effect if we were to make this change? What would be the effect on the Human Rights Commission? Would it increase the amount of time to hear cases? Would you need additional resources to do cases? If you could just address the effect on your commission.
Yes, thank you for the question. So what would happen initially is that we would be scheduling more cases. So right now we're in February of 2022. We are already scheduling hearings into the month of December. So with conciliations, those are happening. Those are, at this point, they're scheduled 2 a week in order to make sure that there's time for, if there's an attorneys on both sides, they have hearing schedules, they have depositions, and a wide variety of things that they're doing. So when we schedule the conciliations at the end of a PC finding, we are taking into consideration everyone's schedule when we schedule the conciliations. So with that being said, if everyone remains, maybe we need to have 3 per week. Maybe there's a little more. I'd have to sit and look at that to see if it makes sense to do that. But if we're already scheduling into November at this point, or scheduling into December at this point, even if there are more conciliations, we're moving them further out. Certainly, if something settles prior to the hearing of that particular month, people are given an opportunity to move up if they are prepared and ready. We do offer that as an option. But what will happen also is cases will settle. So we ask people to continue the conversation. From the beginning, we offer a free mediation program, so people have access to that. They don't lose their place in line if the mediation isn't productive, and they can, they stay in. Whether there's, and if it's a situation where it's something that's a really pressing case and the complainant doesn't want to necessarily speak to anyone representing the respondent, but they are interested in some form of settlement, then our investigators can do a negotiated settlement there on behalf of the person. It's really just exchanging the information. This person is available and interested in settlement. Are you interested? Yes. What are your numbers? Great. And move it forward. So we would have to have more. We would have to at least schedule 4 or 5 hearings per month, with the potential that maybe we'd have 2 per month, given the opportunity that people may settle. And with that being said, our hearing panel is made up of 3 of our 7 commissioners, and these are commissioners that were not involved with the decision, with the fact finding of the case. And so they will listen to a hearing, which could be anywhere from 1 to 3, 4 days. It depends on the complexity of the case. And so these volunteer commissioners would need to sit and listen to this and then deliberate and then make a determination. So maybe and having additional staff, of course, that's helpful, so that you're investigating more of the cases as they're coming into the door, and getting us to a point where once it comes in and it's docketed, then hopefully being able to assign it immediately to an investigator to allow that process to begin, and certainly offering mediation along the way if that's helpful. And then we would need to have the clerk to clerk the hearing. So a long answer to a short question.
Thank you. Any other questions? Representative Simpson.
Sorry, I have one more. Thank you. This is referring back to the questions that Chairman Gordon was asking, and I don't know if this is in your, I apologize if this is in your handout, but do you know how many, if the 8 pro se cases overlap at all with the 9 cases that respondents removed to the Superior Court? If there's any way of knowing that.
I'm not sure that I understand the question.
So I was listening to your numbers, and you said there were 8 pro se courses or pro se cases where the complainant represented themselves. And then there were 9 cases where the respondents removed the case to Superior Court. And I was just wondering if you know or can find out whether those cases overlap.
Great question. And let me see, I might have. So it looks like 2. If I'm looking at this correctly, it looks like of the 9, there may have been 2 that complainant was unrepresented. And so of the remaining ones, then it would be that they were represented by counsel. You're welcome.
Any other questions? Representative Langley.
Thank you, Mr. Speaker, and thank you for again taking my question. I hope I can articulate this clearly. For persons that might not be represented, have you ever found that a case was so egregious that you felt that they were just poorly prepared and inadequate to represent themselves and defend themselves, so that they would have the need for an attorney? And if so, do you have some resource that you could fall back on to access those services for that individual?
Thank you. That's a really good question. Customarily, when there's the intake process and as cases move forward to investigation, we do our best at the commission to give the pro se complainant as much information as possible. But we go up to a point, because we cannot advise them. And the staff is excruciatingly clear that we are not a legal service in terms of providing information on decisions that the complainant should make. What we will do is make suggestions, and we do have a list of, if it's legal services, a few of the complainant attorneys that practice before us. We may give them information, but we make sure that it's excruciatingly clear. We can't give you legal advice, period, full stop. And that's for both parties. We do not provide legal advice. We can absolutely explain to you ad nauseum what the law says or what your responsibility is in terms of where we are in the adjudication of the case, of that particular charge. We can give you as much information as you can stand to take in, but we cannot advise you. And if it appears that the person really needs legal advice, then the investigator, if it's at that point, will make that suggestion. It sounds like you might need some really specialized legal advice that I can't give you. Here's some names, here's some information of places you can look. This is not an exhaustive list, but here's some opportunities for you here. If the complainant is still persisting with that, then it may escalate and the assistant director may take over, or if I need to, I will. But usually talking with the investigator, they can, because they start a rapport with the individual. So usually them saying, "Ooh, I can't advise you. You really should seek legal counsel on this." Is where it stops. But if it needs to move further, usually by the time it's at the assistant director's door, she is emphatic yet polite and calm and saying, "You have to seek an attorney. We cannot advise you." Even if it pains us to not be able to tell you, we know what you should do, maybe, based on the law, but we cannot advise. And our staff, from secretary to investigators to paralegal, very clear, we cannot give legal advice.
Thank you.
You're welcome.
Representative Chase.
I love that smile. Thank you. Sitting here listening to all this, out of curiosity, how many ballpark calls come in that you just say you're in the wrong department, or that really, or just somebody that feels that they've been disheartened, or just, the word I'm trying to think of, but it really is not falling into what you do? Does that happen often, and you have a filter for that?
That's a great question. I do not have even an anecdotal number for you, but to sort of answer the question, yes, we do. So if with the intake person, their job is really to listen and understand where the person fits into our statute. Sometimes it's a situation that it's workplace bullying, right? So the person is having harassment happen, but it is not based on a protected class status. So that isn't anything that we could help them with. I mean, sadly, right? Who wants to be bullied at work when you have to be there 8 hours a day? But that would be something that we are pretty clear that that's not within our statute. Sometimes it's a wages and hours issue. And so we would certainly refer them to the Department of Labor to have that conversation. So if it's something that is clearly not within our statute, there's a little bit of information gathering there at the beginning for intake to try to determine, are you in the right place? And if you're not, then we do have a book of numbers and people that we can refer people to. So we do our best to help them, to refer them to the place where they probably should be. But if the person is emphatic that it belongs here, there's a questionnaire, they can pull it offline, fill it out and send it in, and then we can take another look. You're welcome.
Thank you. Any other questions? You asked for 2 minutes of testimony. I think we're there. Thank you for your testimony.
You're
today.
welcome, and thank everyone for their patience.
Megan Douglas. Right. We need to turn.
Oh, okay. Task 1 completed. Thank you, Chairman. Thank you, committee. Thank you for having me here today. My name is Megan Douglas. I'm an attorney in private practice. I represent exclusively employees, including before the commission. and I've witnessed firsthand the problem that this bill would address. Before I talk a bit about the problem from my perspective, I just wanted to refer back to testimony that Director Maliki just gave. She described referring an employee with a wage and hour issue or some other retaliation issue to the New Hampshire Department of Labor. And I think it's important for the committee to remember that that employee who doesn't have a claim that can be addressed at the commission, but does have a claim that can be addressed at the Department of Labor, that employee has the right under our statutes to be heard fully at the Department of Labor, and the employer has no right of removal. So I think that's an interesting comparison to keep in mind. Okay, the problem, the fairness problem. I hope you'll indulge me. I used to be a middle school teacher, and so I tend to maybe reduce things, complex problems, to simple concepts. Here is what I've come up with in this case. Imagine you're playing a board game, a complicated board game, like Monopoly, and you're playing for a good amount of time, you're making some progress, you're moving your way around the board, you're managing some setbacks, but you're applying the rules, you're doing what you need to do to prevail in the game, and you get to the very end of the board game where you have to make the final push to prevail and to make your case, as it were, to mix the metaphor a little bit. Now imagine that your opponent is allowed to flip the board and make you start all over again. And not start all over again playing Monopoly, but playing a different game, which you may not fully understand and which you may not be equipped to play. That's the fairness problem. I prepared a chart for you to show you what the board flipping looks like at the commission specifically, and it describes the process that Director Maliki already verbally described to you. In my chart, we imagine a pro se plaintiff. His name is Jason. He's suffering racial harassment by his coworkers. He's still employed, but he has a right to file a complaint at the New Hampshire Commission for Human Rights to try to get some relief so that he can continue to stay employed without discrimination. So he calls up the commission and he asks the commission, the intake worker, to take his information. And the intake worker, as Director Maliki describes, will assist in the preparation of a complaint, albeit simply a neutral recitation of the facts as reported. And then an investigator is assigned, and an investigator interviews Jason, asks Jason to produce records, asks Jason to produce witnesses, and it is some work. Then the investigator asks the employer for information, for witnesses, for records, and sometimes the investigator has to come back to Jason and say, Jason, what do you think about this evidence that the employer submitted that says that, you weren't really being criticized for your religious clothing. You were being criticized because by your coworkers because you weren't performing very well and you were holding the team back. And Jason has to rebut that. At the end of this process, which may take 1 to 2 years, and remember, Jason is still employed, trying to hold on to his job. The investigator decides, you know what, Jason, you may not have won the Monopoly game yet, but you do have enough such that you might. And that's the probable cause finding. And the probable cause finding gets communicated to the employer, and the employer says, whoa, wait a minute. I have a do-over right. I play the do-over card. So I don't want to settle my case at the commission. I don't want to have a hearing at the commission. I know that my do-over card will make things very challenging for Jason in court. So I'm going to play it. Well, what happens to Jason? Jason quits because he can't handle this anymore. Or he has to go to court. And his case, especially if it's one of harassment, which regrettably, is not typically understood to be a very lucrative claim, he may not be able to get an attorney who can afford to help him. And that's not right. It's just not right. So I'll be happy to take any questions that you have.
Representative Chase.
Thank you. I guess I didn't realize that there weren't attorneys that were offered. So there isn't any, like if you, never really been to court to have what is it called? A supplied attorney. What is it called when if you don't have, court appointed attorney. So in this scenario, there is nothing like that.
No.
You have to be able to afford an attorney in order to really fulfill your claim and your complaint.
Correct.
I just have a question, and that is, we heard from Mr. Juve at the very beginning about, and his argument basically is an argument of fairness that should you only allow one party to appeal, shouldn't both parties have that opportunity? I guess the question I have for you is, should either party be, what if you took the legislation and said each party is going to be required to accept the decision of the Human Rights Commission?
I think that's what SB 296 would do. I think it would establish that if probable cause is found at the commission, which is it's a preliminary finding that the plaintiff case has merit, that the plaintiff therefore gets to elect to stay at the commission or move to court. But the defendant, the employer, does not have the ability to remove to court after the PC finding.
But if I could just, but still, the complainant has the ability to remove the case to the Superior Court if they want to at that time. So what if neither party were able to do that? They have to abide by whatever the final decision of the Human Rights Commission.
Frankly, I've been thinking about this bill through the lens of the pro se plaintiff. I don't see any issue with a plaintiff trying the matter before a neutral body. That is the commission. It's, I believe, 7 commissioners appointed by the governor. I have no reason to think that the decision by the New Hampshire Human Rights Commission would be any more biased or less valid or legitimate or accurate or just. than a jury. As I've alluded to at the beginning of my testimony, a whistleblower can try their case fully at the department before a single hearing officer. At least at the commission, you've got a body of people who have to come to the same conclusion.
Thank you. Other questions? Representative Lorenzo.
Thank you, Mr. Chairman, and thank you, Attorney Douglas, for taking my question. Now, do you practice in any other states?
No, I don't.
Okay, may I follow up?
Yep, you
Are
may.
you familiar with the Mass Commission Against Discrimination and their process?
Could you repeat that?
Oh,
I
sure.
just had trouble
Are you
hearing.
familiar with the MCAD and their practice in Massachusetts?
I'm not.
Okay.
I'm sorry.
Okay,
I've
so-
practiced exclusively here in New Hampshire.
Okay, I have just one more.
Yep.
So how would you compare New Hampshire's process with the federal process? For instance, EEOC or
Yeah, the EEOC. New Hampshire, the New Hampshire Commission for Human Rights, in my experience over the last 12 years, better investigates the charges before it than the EEOC. We prefer to we have the option in most discrimination cases of filing at the EEOC or the New Hampshire Commission for Human Rights, or both. We usually file both, but electing to have the commission investigate the charge because they do a better job, in my experience.
Other questions? Seeing none, thank you for your testimony today, Attorney.
Thank you very
Douglas.
much.
James, is it Reedy?
Good morning.
Good morning.
Thank you for the opportunity to speak. I'm a management side lawyer. I represent employers, and I work at Sheehan, Finney, Bass and Green in Manchester. I'm the chair of the firm's labor and employment group. I've been in practice for 33 years, and I think it's fair to say that I've had hundreds of cases before the New Hampshire Commission, and I speak in opposition to this bill. I want to start off by saying, however, that I truly appreciate the efforts of the commission and what they're charged to do. And Executive Director Malachi, and I'm not trying to curry favor, even though I do have many cases up there, she's done an exceptional job at trying, as she said, to streamline the process and move things along. She also mentioned that under statute and under the FEPA, which is a cooperative agreement with the EEOC, where cases are dual filed, as Attorney Douglas just referenced, the New Hampshire Commission has an agreement where they investigate on behalf of the EEOC. And it's within 2 years, and there's a funding exchange in that regard. Sadly, because the staffing of the agency is such, and the funding is such, that cases don't move through the system in 2 years. They don't move this through the system typically in 3 years. I just had a case with a decision. It was filed in 2017, 5 years. And justice delayed is justice denied in many regards. And I heard a lot of comments and questions in that regard. One quick comment also with regard to the Department of Labor, because I'm a frequent flyer there, that you have, if you have a wage claim, you can file it either before the New Hampshire Commission, before the Department of Labor, or in Superior Court. Either party can do that. And then there's appeal rights to the Supreme Court. In essence, my testimony is focused on one thing, and that is fairness. Mr. Gervais mentioned that. Others have mentioned that as well. By taking away the respondent's ability to remove this matter after a probable cause finding, and I want to talk about that in a second, is effectively unfair. because the complainant can remove it after 180 days before the commission. And in my experience, sometimes do. But remember, a lot of these cases are taken on a contingent fee basis, and it's more cost effective to leave it before the commission. There were comments earlier about the cost going to court. Going to court, a plaintiff typically will be on a contingent fee basis. It's not an hourly basis like on the other side. But it would be lopsided, one-sided, where one party can remove a court and the other could not. And remember, a probable cause finding doesn't mean an absolute. It means 51% by a preponderance of the evidence. So what is a preponderance of the evidence? It could be based upon written submissions. And in recent years, there have been cases, and this is not a criticism or a disparagement of the commission investigators, sometimes they don't get to talk to the witnesses. I've had that in several cases. They base it on written submissions. They're absolutely overwhelmed. And while there was a pause or a delay with COVID, on average, the commission receives more than 200 charges a year. So if there's a delay in the system, referencing what Executive Director Malachi said, I think there would be a burden further on the commission. You're not going to expedite cases. It's going to push it out even further. So take that case that's been there for 5 years and then setting down for a hearing. No benefit to either party in that regard. And in my case, or in cases that we've had, you've got witnesses that either relocate or memories fade and the like. This bill would not improve that system at all. And if there is an opportunity to improve the system, there are many ways, and I know that that's been looked at and there's been progress. This bill would not do that. In fact, with regard to the hearing process before the commission, my estimation is, as I looked at the record, since 1974, there have been 76 hearings before the commission. So in nearly 50 years, 76 hearings. That's not a lot. And the other is, we appreciate the fact that the commissioners are indeed volunteers, but they're not lawyers and they're not judges. They're lay people, good professionals, but they don't have the formality that you might have in court, rules of evidence and the like, in going through the system. Again, hundreds of cases filed. The statute says 3 years. Again, some older. I think under the current system, the system effectively works. If there's a PC finding, yes, it's not being forced. You have the opportunity to remove the matter to court, and it's a de novo hearing. If this bill were successful, there would not be a de novo hearing, meaning start over again or have a fresh look at the evidence. It would be based on errors of law, and that's a very narrow field. So effectively, and I think it was the reference from Mr. Gervais earlier, is I think that more time, and based upon the many questions today, I think more time is taken to send this back to, if the bill were not killed, going to interim study committee to consider this further. There's a lot to unpack here, talking about the process, how a charge is filed, how it's investigated, the hearing process, and some of the statistics that were referenced earlier. I have a lot of anecdotal evidence, but I'm not going to take up any of your time in that regard. Just based upon my experience, I think while perhaps this was well intended, I think it would actually clog the system much more, and it would also take away the fairness that we referenced earlier. One last point. There's a constitutional argument here. When you have state and federal claims filed before the commission, if the commission under this proposed system issued a probable cause finding and you had to go before the commission for a public hearing, what about the federal claim that they're also investigating? That claim, if there's a probable cause finding, you have 90 days to file in federal court and start all over again. And that is a de novo hearing in that process. So you would have a constitutional problem with the state law claim effectively being adjudicated and the federal law claim, often the same claim, just under two different statutes, having a fresh look. So again, that could be a delay in the system.
Questions for Attorney Reedy? Representative McLean.
Thank you, Mr. Chair. So even if resources could be applied to accelerate the process and we were to eliminate across the board removal for after the finding of probable cause, you still have problems with the mechanism even then because of access to the courts beyond that. Is that correct? So even if we were to do those amendments to streamline and to address the resource concerns and to make the removal fair across the board, you still have concerns with the mechanism.
Thanks for the question, but just to be clear, when you say streamline to make it fair across the board, are you saying neither party can remove or both parties can remove?
So resource issues to accelerate the process, because you talked about, I brought in a claim in 2017, it's just being resolved now. So that resource issues on the one side, and also basically, yes, exactly, nobody can remove it after a probable cause hearing, including the claimant. So if the legislation was amended to basically address those two things, my understanding, you still have concerns with the mechanism on other constitutional grounds, et cetera.
That's correct, and I think I would summarize it this way: the right to jury trial. The hearing before the commission would not be a jury trial, and that doesn't, again, not to be critical of the commissioners in the public hearing process, but you should have a right to a jury trial. And then the other is if you have a dual filing, you would have that right under the federal system, and you would have a conflict between state and federal law. And there'd be a question as to whether or not there was whether or not the state law decision could be entered into evidence in the federal. And I have at least one federal court decision where this says there's no probative value, that the federal court did not accept because of the highly prejudicial nature of a probable cause finding, and it was, you have the right to start over again.
Thank you.
So can I just ask, how long on the average, from your experience, does it take to get from the time of a filing of a complaint to a probable cause finding?
At a minimum, thanks for the question. At a minimum, at least 3 years. More like in recent years, closer to 4 or perhaps more.
And if I could just follow up, so it seems difficult to accept, at least, that somebody has to wait 3 years to get to a probable cause finding, and having done so, gotten to that point, then making a decision to remove it to another venue. And is it possible that the parties could elect to go to the Superior Court at an earlier point in the process, not waiting until you get to that point?
Well, that's what the complainants have right now. After 180 days before the commission, so 6 months, they can remove the matter to state court. They could actually move the matter to federal court as well.
So why not apply the same standard to the subject of the complaint?
The respondents, I would applaud that if you have that opportunity, again, because under the system in the New Hampshire Department of Labor, whether it's a whistleblower or a wage claim, you have the opportunity to elect to go to the Department of Labor or to Superior Court.
I'm just relating it to small claims cases because I'm a small claims judge, but basically you have a limited period. If you want to remove to the Superior Court, you have a limited period of time to do that up front, as opposed to you don't make a finding and then decide to remove it to the court and get a de novo hearing.
Right. Department of Labor, you've got within the statute to file your claim. Under the discrimination statutes before the New Hampshire Commission for Human Rights and the EEOC, you've got 180 days from the last event of discrimination to file the claim, or if you're filing both under federal and state law, you've got 300 days, so 10 months at a maximum to file your claim. And then once filed with the commission in a dual filing, you've got 180 days as a complainant to remove that matter to court. It's after 180 days. So anytime after 100 days, you can remove that matter. There's no maximum. You can do it by this point because you've already filed with the commission.
Thank you. Other questions? Representative Horrigan.
What percentage of the is it these respondents that you're working for? Are they typically companies that have internal procedures in place to deal with conflicts in the workplace, either because they're a larger organization and or the workers have a union or otherwise protected, or these mostly things where everything is informal and it kind of comes out of the blue for the respondent, and then they have to go over and hire you to get them out of the deal with the complaint?
which I would of course applaud. But the the area of employment law, workplace law, since the time I started practicing in 1989, has evolved significantly. Gone are the days of the wild, wild west where you're just an at-will employee, you have no rights. You think of the litany of employment laws on a state and federal level that have been adopted since 1990, and they're significant. With that, employers have responded by having, whether it's in a union environment or non-union environment, public sector, private sector, large or small, with early resolution. The law calls for a prompt and appropriate investigation and resolution of disputes. So an employer would be foolhardy if it didn't have that process. It takes a lot in this economy to recruit and retain talent, and that's not just true in this economy, it's in any economy. So you want to make certain that your workplace is functioning properly, but the law calls for that. And so in my experience, whether we're talking about a small family-held business or a large multinational corporation, they all have those procedures in place. Are they foolproof? Well, clearly not, because people still may not be satisfied with the result, and they have the opportunity to file at the federal level, at the state level.
Other questions, Representative Di Lorenzo?
Thank you, Mr. Chairman, and thank you for taking my question. You know, we talked about the process, and at the end of the process, it's a volunteer board that makes the decisions. Would you consider that a strength or a weakness of the program?
Can I say I feel strongly both ways? I just appreciate the commissioners that volunteer their time. They're all professionals that volunteer their time and their skill sets to looking at cases when they can. But otherwise, there's also an investigating commissioner, someone who wouldn't be a part of a public hearing, who looks at the investigation and makes suggestions until a decision, whether it's probable cause or no probable cause, is issued. So I think there's a benefit to the commission, certainly. There are ways to improve. Yes, I think that the improvements would be focused on, as Executive Director Malachi said, at the intake and investigation process, and that would be the resources that we talked about earlier. But from my perspective, I think the hearing process, in a case I can proceed to public hearing if my client, if it makes sense in that regard, or we can go to court. So we have that choice, and it's on a facts and circumstances basis. But so, as I said, there've been some 76 hearings over the last 48 years. So parties do elect, and including employers, don't remove to court, and they go to before so there's that option available. My position is that option should remain.
Okay, other questions? Thank you for your testimony.
Thanks so much.
Appreciate your 3 to 5 minutes max. And Samantha, is it Huning?
Thank you, Chairman Gordon, and committee members, for this opportunity to talk to you today.
You need to get next to the microphone so we can.
Apologies. Thank you, Chairman Gordon and committee members, for this opportunity to talk with you today. My name is Samantha Hearing. I'm an attorney practicing at Douglas, Leonard & Garvey in Concord, New Hampshire. A large portion of my practice is plaintiff's employment law, so we represent the employees. I want to focus you in on 2 points. We've heard a lot of stuff today, but I just want to boil it down to fairness and state resources. Those are the most important things that we have to talk about today. A question was raised, why not eliminate the ability of both parties to remove? Why not just keep everybody at the commission and let them live with what the commission decides? I want to answer that by telling you how we got here in the first place. 354, when the original removal provision was put in, it was added because sometimes plaintiffs have claims that the HRC cannot hear. For example, wrongful termination claims. And so what would happen in a case where an employee has a claim that's subject to the HRC's process, but it also cannot be heard there? They would go through the process at the HRC. They would then have to file the separate claim in court. The result of that is telling the HRC and the court the same set of facts, the same set of witnesses, really trying the case twice just to bring 2 claims. So to eliminate that waste of resources, we put in the removal provision so that plaintiffs can remove their case to court because they have an attorney who says to them, look, we're going to litigate this case twice. We might as well just remove. Let's make this more efficient for everybody. That's how we got here. So if we eliminated that removal right for the complainant, I feel that we would be wasting our state's resources by having cases litigated at the HRC that could just move through the court system. And we would be clogging up the HRC. I also want to note briefly, no one testified against this bill in the Senate. It was passed by voice vote on consent calendar. And I want to talk about the fairness issue. The United States Supreme Court long ago held that people who bring claims against someone else, it's their right to decide the forum that hears their claim. It's a longstanding principle in this country. I also want to talk about the resource differential between employer and employee. So we've been talking about the data today. 2015 to 2021, in a 7-year period, there were 28 times that the respondent removed the case to court after the cause finding. So I can't tell you what happened in each of those 28 cases, but I can tell you what I see the potential to have been, which is that you have somebody like John, who is a busboy at a restaurant. He's sexually harassed by owner number 1. He goes to owner number 2 and he complains and he says, please help me fix this. I just want to work. I don't want this guy touching me while I'm just trying to do my job and clear tables. Owner number 2 doesn't care and nothing happens. The harassment continues. John either has to keep going to work and endure the sexual harassment, or he could decide, you know what, I'm going to do something about this. I'm going to file at the Human Rights Commission. John quits his job. He files at the Human Rights Commission. He looks for an attorney to take his case, and he gets a new job 3 weeks later at a new restaurant. Now John's problem is that when he calls an office like mine, I can't take his case because I have to get paid. John makes a low wage as a busboy, so he can't afford to pay my hourly rate. The other problem for John is that with 3 weeks of wage losses and as a low wage earner to begin with, he's not going to have the type of wages that would allow me to recover my fees on a contingency fee basis. So John's going to have to do this without an attorney. He goes through the commission process. He convinces the commission that owner number 1 was touching him while he was trying to clean tables, and he gets a probable cause finding. But the owners don't want to deal with this, so they remove to court, hoping, like Attorney Douglas testified, that this will make it too difficult for John to continue. It'll make him start over. John does give up. He's got to go to college. He doesn't have time to deal with this. He doesn't have the knowledge or the resources. What I want to focus not just on the fairness to John issue, but I want to ask you, representatives, what message are we sending to employers if we allow them to do that to employees like John? If we give them a sort of, trump card at the end of the game that they can play to just get themselves out of trouble. I also want to talk about the employer's inability to remove the case doesn't somehow make it more difficult for the employer. Regardless of which forum the employer is in, they still have a duty to plead. The employee still has a duty to plead their claims by a preponderance of the evidence, regardless of the forum. So eliminating the employer's ability to remove doesn't change that. They still have that. The employee still has the same burden. There was a question earlier from Representative DiLorenzo, I believe, who asked, what about people who have something very egregious happen to them? Is it possible that these pro se people could give up because they can't go to court and they don't have the resources to deal with this? In my experience, outside of the small claims arena, plaintiffs are not equipped to represent themselves in litigation. And that's not to say anything negative about the ordinary citizen, but it's just to emphasize the complex process that is filing a claim in court and taking it to the end. I also want to talk about some opposition testimony that I heard today. At one point, I heard testimony that an employer can remove wage and whistleblower claims from the Department of Labor. That's false. There is no ability for the employer to remove those claims. I also heard testimony that keeping a case at the commission and scheduling it for a hearing will just push the resolution at the commission out farther. It'll just keep the timeline going. That's ignoring the reality of the timeline that we experience in court. which doesn't fare much better than the commission's timeline. So keeping it at the commission and waiting for the commission's ability to give you a hearing, or moving to court and starting over from scratch, keeping it at the commission is not going to extend that. If anything, the timeline of the case is going to be extended by putting it into suit and starting the process over. There's a new complaint, there's a new answer, there's a new schedule for the case. There are new people to be questioned. There are new questions to be answered. It's all from scratch. I also want to talk about the constitutional argument about the right to a jury trial. Our own New Hampshire Supreme Court decided that the constitutional right to a jury trial does not attach to legal rights that didn't exist back in 1794 when our Constitution was passed. In 1794, we didn't have 354A or the Human Rights Commission, meaning there is no constitutional right to a jury trial for those claims that would be heard at the commission. I think representatives, that concludes all of the points that I wanted to make, but I'm happy to accept your questions.
Questions, Representative Chase.
It's not really a question. I missed your name and where you are from.
Samantha Hearing. I work with Douglas, Leonard, and Garvey in Concord.
Thank you very much.
Thank you.
Any other questions? Representative DiLorenzo.
Thank you, Mr. Chair, and thank you, Attorney. I'm going to ask you the same question that I asked the previous speaker, and I wanted to get your take on the Human Rights Commission's process that ends in volunteers making a decision. I'd like to hear your take on that. Thank you.
I don't have any issue with volunteer, and I apologize, I can't see you very well around this, but I don't have any problem with volunteers making a decision at the end, because the volunteers are provided with the framework of the law that applies. As long as that's provided, then I think that volunteers can adequately make a decision if they've been presented with the relevant evidence.
Thank you. Any other questions? If I could just, and as has already been mentioned, justice delayed is justice denied. And is there, just in terms of looking at the legislation, is there a way of allowing both parties to make an option to go to the Superior Court instead of the Human Rights Commission earlier in the process, as opposed to after a probable cause finding has been made?
I suppose it would be possible to do that. I believe, as the last speaker said, at 180 days, the complainant can remove to court. It's possible that the statute could be amended to give respondents that same ability. I think what we're still going to experience in that case is resource differential between the parties. When we have small employees who don't have a lot of wages, can't get a lawyer, versus a company who, even if a mom and pop shop, has some more resources at their disposal than that employee, by forcing the employee into court even earlier in the process, denies the employee from pursuing claims that we've decided are warranted under our laws.
Right. And if I could just, and I get the issue that the Human Rights Commission is something that may be more user-friendly, particularly to pro se litigants, and less intimidating than going to the Superior Court. So I get that. And I get the idea that you wait to a probable cause hearing, which might be, from what I understand, out 3 years, and then the employer or respondent at that point in time has the ability to basically have a de novo process. So, which just seems to delay everything. So what if the parties, if you wanted, if once you file at the Human Rights Commission, the complainant is committed to be at the Human Rights Commission, they can't remove, but you give the employer the right to say that if within 90 days after having received a complaint, you have the right to have it removed to the Superior Court for a jury trial or whatever else, instead of that whole 3-year delay? Would that be something that would be more fair?
I think that, my issue, Representative, is that I don't see a lack of fairness for the employer here. Because the New Hampshire Supreme Court has held that they're not entitled to that jury trial in court anyway, and because the United States Supreme Court has held that the person who files the claim is the person who has the right to decide which forum hears it, not the other way around. So I don't see the fairness issue based on our court's precedents. But that's something that certainly that could happen. The statute could be amended in the fashion that you suggest. I would again come back to the unfairness that would result to people who can't get an attorney to handle their claims, and it's less about court being intimidating and more about just, I'll be candid, I'm a new attorney. I still don't know everything that I'm doing. I still have to ask my colleagues daily for assistance with the litigation process. I can't imagine not having the education and background and assistance that I have and trying to proceed through this process without all of that. It would be impossible. The other thing I want to emphasize too is that one of the great advantages of the Human Rights Commission to employers is that the process is confidential. You don't have to experience bad publicity for claims that may be without merit. You can keep things confidential at the commission and let things be decided there. It's also informal, easy to deal with, and very, very cost effective compared to court.
Thank you. Any other questions? Seeing none, thank you for your testimony today.
Thank you.
Beth Derrick.
I was just checking to see if I was going to say good morning or good afternoon, but we're still in the morning. Good morning, everyone. My name is Beth Darragon. I'm an attorney, an employment law attorney at Pastore Crans in Concord, New Hampshire. And for the record, I'm from Bosquen. I always like to note that. So I'm not going to spend a lot of time repeating the testimony that's gone forward, but I would like to spend a little bit of time clarifying some of the remarks that have been made. For a start, I think it might be helpful for you to know that I represent both employees and employers, have done so for about 16 years. So currently, I was trying to tally the number in my head, but I think currently at the Commission for Human Rights, I have an equal number of clients who are on the complainant side and an equal number who are on the respondent side. So I can, at least give you what I like to think is a well-balanced view of representation of both in the same forum in the process. I testify here today in opposition to this bill. And my biggest issue is that this denies the jury process to my respondent clients. So to my respondent clients who are the recipients of a charge of discrimination and ask me, okay, Beth, now what's going to happen? What's the process here? Currently, I'll say to them, well, we will stay at the commission and have to stay at the commission until there's a probable cause or no probable cause finding, as you've heard earlier today. And then they say, and then what happens? Well, at that point, we have a choice. We can proceed with a hearing at the commission, or we can remove to court. Now, to my complainant clients, ask me the same question, Beth, what's the process? Well, here's the process. After 180 days, because cases, as you've heard, are pending at the commission for a lengthy period of time, and that's no criticism of the commission. I interned at the commission as a law student and was one of those intake folks who had to listen to the types of folks who were calling in and asking whether or not they had viable claims. So my heart is always there at the commission. I'm actually a mediator as well for the Commission for Human Rights. So I wear many hats. But for my complainants, I can say, okay, well, after 180 days, we've reached a juncture. We can decide whether or not we want to file in court and avail ourselves of typical discovery practices, right? Depositions, interrogatories, requests for production of documents. And is it worth us to avail ourselves as though? On the complainant side, oftentimes it is, because the complainants don't have the records, right? The employer has the records. Oftentimes, strategically, it is a good idea to remove. We want to understand what the employer has. We want to know what records they have, what emails, what text messages. How else are we going to get them? How else am I going to assess the case? Sometimes strategically, it is worth making that move. But my complainants have the right and opportunity to do that. And they have the right to be heard in front of a jury of their peers and to have the case adjudicated applying the rules of evidence. My respondent clients, if this bill were to go into law, would lose that ability. They have no right to a jury trial. They have no right to be heard by their peers. They have no right to a strict application of the rules of evidence. That's a huge disparity in my view. I represent both sides. I'm looking at it from both sides. But as an attorney, I have a big issue with one side being denied equal justice before the law and to be able to be heard by a jury of their peers. I just want to make a couple of points. Attorney Reedy earlier specified and stated about the New Hampshire Department of Labor process in regard to wage claims. The filing party can elect whether or not to file at the New Hampshire Department of Labor or in Superior Court. That's an election that can be made. It's not a removal issue. That's not the statement that he made. So that, for those reasons, I'm opposed to the bill. I want to see both parties be able to make informed decisions, strategic decisions that are based on their own considerations and be able to be heard by a jury of their peers if they so choose. And I thank you very much for your time. I am still well within my 15 minutes and I'd be happy to answer any questions.
Okay, Representative McLean.
Thank you, Mr. Chair, and thank you for taking my question. One of the things at the core of Attorney Hearing's support behind the bill, she was just talking a lot about the resource delta that exists between the employer and the claimant. And she stressed that in many cases, it might not even be possible for a claimant to be able to get representation. And she kind of went through the arguments for why that would be so. You, however, represent an equal balance of employers and claimants. In the case that she brought forth, where we have a busboy who is very low compensation, is there any claimant within your clientele that is at that level? Or I'm just trying to get a feel to understand the weight of that argument for the resources.
Thank you for the question. So damages that can be awarded under Title VII and under 354A don't only include lost wages and future lost wages. It also includes compensatory damages. So that when an attorney is assessing the viability of a claim, and I'd be happy to take the prior example of the busboy who was assaulted essentially at work, right? He was inappropriately touched. That and most likely suffered emotional distress damages as a result. it may be true that he doesn't make a lot of money. It may be true that the lost wages calculation is low. But you know what could be high? The compensatory damages. That's egregious conduct when someone touches someone inappropriately. And if there are enough facts and evidence to support that, then I question whether or not there is an attorney in the state of New Hampshire who would necessarily not take that case just based on lost wages. And but that gives me an opportunity to give you a real life example too. So years ago, when I was at Upton and Hatfield, and I was a new lawyer there, a client came in who had a no probable cause finding from the commission, and she was pro se. She came in and spoke with Heather Burns, who is a partner and is to this day at the firm, and pitched her case to us. We took the case. No probable cause finding. She was a pro se client, took the case, went to federal court, and we prevailed. And so I give that as an example because it is not all doom and gloom. We do have real cases and real examples of pro se litigants being at the commission, even getting a no probable cause finding, and there are attorneys who will assess the case on the merits and make judgment calls about the viability of those claims. Thank you.
Representative Horgan.
Thank you very much. And I guess I missed the beginning of your presentation. What your name was? Bertha what? Dariaga?
Close. Beth Daragon.
Oh,
just
I'm
not
sorry.
dragon. Just
Beth Daragon. Oh, that's-
one letter makes a difference.
Yes, you have a lifetime experience explaining
Yeah.
how to spell your name. Like, when the so when you're if you're working for a responding client and they come to you, are they typically surprised that this complaint is come across their desk, and or is they typically something where there's been a long running conflict in the workplace and other avenues, internal avenues have been explored and didn't work out? Or
It's a mixed bag. Thank you. It's a mixed bag. Sometimes where it's a client who I have represented through an internal complaint process, and they've conducted an investigation and so forth. There's still the possibility that when the client leaves the workforce, they still might file a charge of discrimination. In those instances, it's, we receive notice of the charge and say, oh, we thought, that was all handled well and whatever, but we know where that's coming from. But then I have clients who are just, they had no idea that this was coming, and the person hadn't raised any issues in the workplace, and the first they hear of it is in a charge that's been filed. And the other point I wanted just to make, it occurred to me in terms of cost to the employer. I do think it's important to understand the insurance piece of this. Not, there may be a misunderstanding or a misapprehension that employers all have coverage for these types of claims, insurance coverage. It's not covered under their general liability practice coverage unless they have a separate employment liability program, coverage insurance program. They don't have insurance for the claim. I have several clients now where they do not have insurance coverage. I have one client now does have insurance coverage. The deductible is $75,000. So that's not really coverage. So I want to raise that because there is a cost to the employer. They're not all covered by insurance, and even if they are covered by insurance, oftentimes there is a sizable deduction that has to be met.
Are there any other questions? Seeing none, thank you for
Okay,
your
thank you
testimony.
very much.
Just a hint, when you ask for 15 minutes to testify, sometimes you get called last, so.
Oh.
I did receive one additional card, and that's from Marissa Chase.
Good afternoon, representatives. I don't like being between you and your lunch. For the record, my name is...
You did ask for 1 minute.
I did. My name is Marissa Chase. For the record, I'm the executive director of the New Hampshire Association for Justice, a statewide professional association of trial attorneys. Both Megan Douglas and Samantha Herring are members of our organization, and we requested this bill be introduced by Senator French. As Samantha mentioned, we had not heard of any opposition to this bill this session. There was no testimony in opposition in the Senate. I had not received any indication that this had opposition, so I'm a little surprised today. But as always, we are willing to work with stakeholders if there can be a compromise. I don't know that that's possible on this issue, but Mr. Chair, you know I like to try. In New Hampshire, I just want to point out one thing that Attorney Daragon said. In New Hampshire, we experience conservative juries. It's overwhelmingly common that emotional distress damages that Ms. Daragon spoke of for the busboy example are not given weight by our juries. One mechanism for judging the amount of emotional distress damages is by looking at lost wages. So again, I think I've said this before, probably 100 times to some of you. In New Hampshire, these cases are taken by contingency fee. That means that the lawyer fronts all the costs of litigation and does not get paid by the client until and unless they prevail. That is an enormous risk assessment that lawyers, especially a small firm, have to make. So a lot of our plaintiffs' attorneys, I can tell you on our listserv, where we have over 500 members that talk about these issues. There's an employment law practice group in the state as well called NELA. The overwhelming amount of plaintiffs' lawyers in this state do unfortunately turn away many complainants, and we do see a lot of pro se litigants that are removed to Superior Court after a probable cause finding at the Human Rights Commission that give up. I mean, that is the experience of our members. I'd be happy to try to find, specific data numbers on that, but I can tell you that that's something I hear frequently.
Other questions? Seeing none, thank you for your testimony today.
Thank you. Enjoy your lunch.
Is there anyone else who would like to testify on Senate Bill 296? Seeing no one, we will declare the hearing closed. And thank you everyone for testifying today. And we'll recess. The committee will be in recess till 1 o'clock. Okay, we'll call the House Judiciary Committee back to order. Our next item on our agenda today is a hearing. It's a hearing on Senate Bill 302, establishing the Personal Privacy Protection Act. And the primary sponsor of this bill is Senator Birdsell. And Senator, would you like to introduce your bill?
Thank you, committee. Thank you, Mr. Chair. For the record, my name is Regina Birdsell, state senator for District 19, which encompasses the towns of Derry, Hampstead, and Windham. And I am the prime sponsor of Senate Bill 302. The objective of 302 is basically, sorry, I have the wrong list, was basically to make sure that donors' names are kept private. And this comes on the heels of one Supreme Court decision that was made recently in AFP versus Bonta, and also I believe it was a 1956 U.S. Supreme Court decision with the NAACP. And basically what it does is it protects the donors and of those on 501c3s. It does not impact any election bills. So, sorry, I lost my my list. But this bill is virtually, it's very bipartisan. We have the ACLU in favor of it. We have the AFP. We have the Coalition of Domestic Violence is in favor of this. And there are a long list of organizations that are actually in favor of this. So with that, I will end my testimony.
No, thank you. Are there any questions for Senator Birdsell? Representative Simpson?
Thank you, Mr. Chair. Thank you for taking my question, Senator. Do you have a copy of that list that you could share with us either now or over email? That'd be helpful.
I do.
Great, thanks.
Other questions?
There will be other individuals behind me that can be a little bit more detailed on the piece of legislation.
Okay. Representative Horgan, did you have a question?
We have many 501c organizations administering state programs. Perhaps most famously, the new Educational Freedom Account program. So, what does this bill do to protect the taxpayers' right to make sure that the money that these 501cs are expending is expended properly?
Well, I think that question can be answered with someone from behind me.
Okay.
Thank you.
Well, thanks. Any other questions? Seeing none, thank you, Senator.
Thank you.
Diane Quinlan.
Good afternoon. I have written testimony. Would you like me to present this now?
Yes, if you just give it to Representative Murner, he'll make sure it gets circulated.
Mr. Chair, members of the committee, my name is Diane Quinlan. I'm the Assistant Director of Charitable Trusts at the Attorney General's Office, and I'm here to express our opposition to Senate Bill 302. We recognize that one of the purposes of Senate Bill 302 was to encourage philanthropy. It's a goal that our office shares, but we are concerned that this bill would actually have the opposite effect. The bill would mean less transparency in the governance of charitable organizations and will make it more difficult for our office to fulfill our oversight responsibilities, so that donors can have more confidence that their donations are used for their intended purposes. I'm going to be brief because I've submitted written testimony, but when considering this bill, it's important to note that the ultimate beneficiary of charitable nonprofits is the public, and the public therefore has an interest in them. And the Attorney General's responsibility to protect the public's interests in charitable organizations is grounded in common law. Well before 1943, when the legislature enacted a law establishing the Director of Charitable Trusts as an office that's wholly dedicated to the oversight of charitable trusts and charitable organizations. It's also important to note that the vast majority of members of governing boards of charitable nonprofit corporation or organizations are volunteers. While the bill was amended in the Senate to allow our office to request the names of board members in annual reports, the bill as amended would not allow our office to request the names of board members in connection with the registration process when charities register with our office. This is a time when we're often able to catch and can address things like conflict of interest transactions, pecuniary benefit transactions, and address issues regarding whether or not the board is composed in accordance with state law. This bill would also prohibit other public agencies from requesting the names of volunteer board members and would prohibit all public agencies, including our office, from disclosing those names in public reports, in assurances and discontinuances, in lawsuits, and in connection with right-to-know requests. In the past year, we had a case that would have been negatively impacted by this bill. The case involved an organization that purportedly was formed to support breast cancer patients and their families, and a married couple who served as volunteer board members. It's the president and the treasurer. After we received an anonymous tip that the charity was a scam and that the president and treasurer were using the funds for their own personal purposes, we attempted to contact the charity on numerous occasions by telephone, by mail, by email, and we issued 2 administrative subpoenas in accordance with RSA 724. But the board members failed to respond to any of those efforts. We subsequently brought a lawsuit against both the charity and the couple. And when we did that, we issued a media release. The media release, which named the president and treasurer, effectively stopped the fundraising for the charity. And we received from the public a number of calls with information about those 2 individuals that we were able to use in connection with our court case. That information was provided to the court, and ultimately the court issued a judgment shutting down that sham charity and holding those 2 individuals accountable. Senate Bill 302 would also prohibit public agencies from requesting the names of donors and from making them public. First, our office does not routinely ask for the names of donors. We don't need it and we don't ask for it. That's unlike in other states, but we do not routinely ask for it. But there are times when we do need the names of donors. For example, when we're trying to provide restitution to donors, we need that information. Also, when we are enforcing charitable gift restrictions in charitable trusts or in testamentary gifts, like in wills, we need to file, we may have to file a petition in court. Under the terms of this bill, we would have to file those petitions under seal. So we believe that Senate Bill 302 addresses a problem that really doesn't exist in New Hampshire, and it would be detrimental to the legislature's stated goal in the Voluntary Corporation Act of encouraging in charitable nonprofit corporations a, quote, connection with the public and, quote, public confidence. For these reasons, we urge the committee to report Senate Bill 302 as inexpedient to legislate, or in the alternative, to refer to the bill to further study. I'd be happy to answer any questions.
Questions? Representative Horgan.
I don't know if you can answer this, but I'll ask the same question I asked Senator Birdsall a few minutes ago, which is how would this bill impact the state government's ability to monitor 501Cs which administer state programs. I guess I specifically mentioned the controversial new Educational Freedom Account program, but there's probably dozens of 501c3s across the state who are administering other programs.
Right. So this bill impacts all nonprofits too. I just want to point that out, and not just charitable nonprofits, 501c3s. Unfortunately, I can't answer that particular question because I'm not involved. From our perspective, it's more difficult for us to monitor the, if we don't have the information about board members and that sort of thing, to address the our oversight responsibilities.
Other questions? Seeing none, you're off easy.
Thank you.
Thanks. Elizabeth McGuigan? Did I get it pronounced right that time?
You did. Thank you, Chairman. Thank you for the opportunity to speak today regarding SB 302. I just want to point out I did pass out a copy of my testimony as well as a statement from the organization People United for Privacy, who is not able to be here today. So my name is Elizabeth McGuigan. I'm Director of Policy for the Philanthropy Roundtable. The Roundtable is a network of charitable donors working to foster excellence in philanthropy and to protect philanthropic freedom. Senate Bill 302 would help strengthen the vitality and the breadth of civil society in New Hampshire. It would uphold a key pillar of philanthropic giving, the right of charitable donors to keep their giving private if they wish. Throughout our nation's history, the norm has always been that people are allowed to choose for themselves whether to be public or private in their giving, and only in a very narrow set of circumstances, such as direct contributions to political parties and candidates, may this long-standing norm be set aside. Now, in a time of deep division and with the rise of so-called cancel culture, the choice to remain anonymous in charitable giving is crucial. Donors to charitable organizations may have concerns that they're giving to causes that are controversial now or may become controversial in the future, might trigger retaliation. It's because of this concern that in 1958, the U.S. Supreme Court ruled that the state of Alabama could not force the NAACP to reveal its members and donors because doing so would infringe on core First Amendment rights by exposing them to, quote, economic reprisal, loss of employment, threat of physical coercion, and other manifestations of public hostility. The right to give and associate privately has been upheld over and over by the Supreme Court, including in last summer's Americans for Prosperity Foundation case. However, it's not just the fear of harassment or retaliation that leads some donors to wish to remain private. Anonymous giving to charity has important religious, cultural, and practical roots that extend back at least 2 millennia. Nearly 2,000 years ago, the Roman senator and philosopher Seneca the Younger wrote, quote, "How sweet, how precious is a gift when he who gives does not permit himself to be thanked." Faith traditions, including Christianity, Judaism, Islam, and Hinduism, throughout history have also strongly encouraged anonymous giving. Many philanthropists prefer to give anonymously in order to avoid being inundated with unwanted solicitations. Others prefer for the attention to be focused on the good work of the charities that they support rather than on themselves, such as the late pop singer George Michael. His generous support for causes including aid to cancer patients and helping abused children was kept anonymous in large part for this reason. And New Hampshire's citizens and residents are no strangers to anonymous giving. For example, in December, an anonymous private foundation matched donations up to $100,000 for the New Hampshire Food Bank, in what's become now an annual gift for the organization. In 2017, the food bank also received an anonymous $1 million donation, which included funds for the organization's culinary job training program, mobile food pantries, and to reduce costs for the group's 430 partner agencies. We don't know why these givers chose to remain anonymous, but what we do know is that communities throughout the state benefited from their unheralded generosity. Now, most, if not all, charitable organizations in the state also pledge to honor donor privacy, knowing that the value of charitable giving is important for the communities that they serve. Senate Bill 302 would protect the long-standing and vital norm of allowing donors to charitable organizations to remain private if they wish. Without the protections of this measure, charitable organizations would be at risk in the future of having to violate the privacy of their donors. In the event of forced disclosure for even one organization, many who prefer to remain out of the public eye for a wide variety of reasons would simply stop giving to a wide range of groups, limiting the important work that New Hampshire's charities do. So, in short, New Hampshire must proactively protect those that wish to give to charitable organizations and must not allow forced disclosures to chill giving in the state. SB 302 would protect this norm, and I encourage you to consider it. Thank you.
Are there questions? Representative Chase.
Thank you, Mr. Chair, and thank you for taking my question. I'm just curious because you're really focusing on the donors and not all of the other things that are in this bill. If donor was removed and people could stay anonymous, would that satisfy you guys? Well, you know what I mean.
Thank you for your question. I think that we do focus a lot on charitable givers, but I think there are a lot of ways that you can be a donor besides financial gifts. If you are a volunteer board member, for example, you may not wish to have a public association, but as the Supreme Court ruled in the Americans for Prosperity Foundation case, the right to associate privately is an important corollary to freedom of speech.
Other questions? Seeing none, thank you for your testimony
Thank you.
today. Olivia Zink.
Good afternoon, members of the committee. For the record, my name is Olivia Zink, the Executive Director for Open Democracy Action, which is a nonpartisan nonprofit organization based here in Concord with over 35,000 members. And our mission is really around to protect our democracy. And I live in Franklin, New Hampshire. And I want to thank you for the opportunity to testify in opposition to this unnecessary legislation. Granite staters across the partisan perspective and demographic lines consistently support transparency in the democratic process. In recognition of the critical role that disclosure plays on shining a light on the political influence of wealthy special interests and to hold elected officials accountable for and the public at large. This legislation would reduce the accountability in our political system, making it easier for wealthy special interests to make funding in our elections and making dark money in New Hampshire politics a little bit darker. This moves transparency in the wrong direction. Real transparency is about knowing who's spending big money in our elections and holding our government accountable. On page one, line 31, it talks about exemptions. And I want to specifically talk about on page 2, line 5, the exemption for campaign finance. It is narrowly defined as 664-4. But the AG's responsibility to enforce campaign finance is in 666. Also, I just got a new book of the election laws. It's 419 pages, and this is only exempting the 26 pages around 664 of this bill, not all of the important disclosures that are important in election law. I also wanted to speak about the exemption for lobbyists, which is line 3 on page 2. New Hampshire lobbying laws really are behind many other states in public disclosure, and I think it's important for the public at large to know who's spending money to influence. And I did post a NHPR story that lobbying is nearly impossible to follow the money in New Hampshire, and also quoted former Attorney General Gordon MacDonald that we need to do better with respects to lobbying disclosures, and we need a standard of review for those disclosures. So I think it's really important when you look at campaign finance and lobbying, how narrowly this is scoped those exemptions are not broad exemptions. It also does not exempt municipal campaign finance. So if a community wants to have those donors disclosed on who's spending money in local elections, those would also not be under this exemption. Therefore, I think it's really important that voters need to know who's influencing and spending money to influence our government. So please either vote interim study or ITL on this bill so that we can protect New Hampshire and our important Granite State from outside influence. Happy to take any questions.
Questions, Representative Smith?
Thank you, Mr. Chair. Thank you, Mrs. Zink. It's always a pleasure to see you. When the prime sponsor spoke a little earlier, I might have misheard her, but I thought she said that this does not apply to electoral politics. And yet you are saying that it does. Can you help me understand the difference of opinion?
Yeah, so page 2, line 5, where it talks about campaign finance, it only exempts RSA 664, which is only 26 pages of the whole book of of election laws. So the piece around the AG's enforcement is in a different statute for campaign finance laws. I think you want to at least allow the Attorney General, if they're investigating donors, to be, able to do that work of investigating donors, but they're not under this exemption. This exemption is only this sort of small part of the total loss.
Thank you.
Other questions? Tim? Excuse me, Representative Horgan.
Well, thank you, Mr. Chair. So I've something that goes on a lot, even the existing law, and this doesn't apply to you specifically. You're wearing an orange badge. You file complete disclosures with the Secretary of State's office. We have a large number of individuals who come here to the State House over and over again who don't have the orange badges, aren't filing the disclosures because they claim they're just advocates and not lobbyists. So would this bill do anything to solve that problem, or would it make it even worse?
I know that there was one institute that rated New Hampshire a D in lobbying disclosures. I think we rank pretty low in the threshold that's needed for lobbying disclosure. And also, if we do fix RSA 15, which is the lobbying law, to make more broad disclosures for lobbyists, would this just apply to the statute as written currently, or would it apply more broadly if additional lobbying disclosure is ever passed? And I will say that I have worked to try to increase lobbying disclosure and failed pretty miserably. So it's not a popular topic.
Any other questions? Yep, Representative Wolper.
Thank you, Mr. Chairman. Thank you for taking my question. I am confused. So RSA 664, as far as I understand it, which I don't have the laws in front of me, but as far as I understand it, RSA 664 deals with the political donations to political committees. If Wogan, and this bill talks to donors, so isn't that the appropriate part of the law for it to address?
I think yes, 660, it should appropriate 664, but should it also appropriate 666, which allows the Attorney General to investigate the law under 664?
Are you all set?
Mm-hmm.
Okay. And there are other questions? Seeing none, thank you for your testimony today. Nathan White?
Good afternoon, Mr. Chair, members of the committee. My name is Nathan White. I'm from the Department of Health and Human Services. I'm the Director of Contracts and Procurement at Health and Human Services, and I'm here just to speak on one technical issue. On page 1 of the bill, line 23, there's a provision that would prohibit public agencies or public bodies from requesting or requiring a current or prospective contractor or grantee to provide a public agency or public body with a list of entities exempt from the federal income tax under Section 501C of the Internal Revenue Code to which it has provided financial or non-financial support. So our department on any given day has between 800 and 1,000 active contracts. Roughly 60 to 70% of those contracts include federal dollars. Every federal dollar that we receive that we provide in a subaward or we provide in a grant agreement or whatever it might be, those are subject to 2 CFR Part 200, commonly known as Federal Uniform Guidance. Federal Uniform Guidance requires that we protect those funds. We have to follow certain procedures. We have to conduct risk assessments. We have to conduct monitoring once those dollars go out the door. And as part of that, we do sometimes, we act as a pass-through entity where we provide funds to a contractor, and then that contractor or subrecipient, they then provide a subaward. It would be challenging for us to oversee and monitor those funds if we were unable to ask our immediate contractor who did they provide subawards to. So the Domestic Coalition for Domestic and Sexual Violence, we commonly, we will give them X amount of dollars for X purpose, and then they will provide those to 12 member organizations or crisis centers. That's just an example. So this particular provision would be challenging for us to still comply with the federal requirements that we're subject to. Another more technical aspect, and I apologize for being the one here bringing the technical nuanced aspects that are relatively boring, honestly. But another key provision here, though, is our standard state terms and conditions, P37, that requires every state agency, this isn't just DHHS, this is any agency, whether it's general funds, federal funds, or other funds, to review and approve any subcontracts that a contractor that we provide funding to may have. So that's just another potential issue that I just wanted to elevate to the committee.
Are there questions? Seeing none, thank you for your testimony today.
Thank you.
Greg Moore.
Good morning, Mr. Chairman, members of the committee. Thanks for the opportunity to speak here today. For the record, my name is Greg Moore. I am the State Director with Americans for Prosperity here in New Hampshire. And I'm here today to speak in support of Senate Bill 302. I actually come here wearing several hats. I am the State Director for Americans for Prosperity, the State Director for Americans for Prosperity Foundation, and someone who sits and has sat on several nonprofit boards, as I'm sure a lot of the other members of the committee have, of local New Hampshire nonprofits. So I come at it from a number of different perspectives. I think talking a little bit about the history of this issue is important to understand sort of the rationale for the legislation. And I'll just say that we were not involved in the development or construction of this law, but when you're the named plaintiff in the most recent Supreme Court case, it kind of pulls you into an issue like this. So the donor protections exist from the mid-50s. This was in the beginnings of the civil rights movement. The Attorney General of Alabama requested the donor records from the NAACP. Now, I'm sure you can imagine why the NAACP would be fairly hesitant to hand those over, and the chilling effect it would have on future contributions, importantly for them, but also for their donors, the impact that would have on them. And of course, the Supreme Court ruled that this is protected under the First Amendment, under the Free Association Clause. So Americans for Prosperity Foundation was surprised in 2015 when the California Department of Justice demanded our donor records. We obviously brought litigation and what went on for 6 years before there was an ultimate resolution last year in the U.S. Supreme Court, which again reaffirmed the right to the privacy of donors. And I actually have a list of, there were 300 different groups that joined in amici briefs on that particular legislation, and it's as diverse as from the ACLU to the Human Rights Campaign to the Gun Owners of America to the Reason Foundation. So it's literally all over the map, including humane societies, private universities, et cetera. I'm happy to give that out to the committee. Now I want to point out this is not about us. I can't imagine any attorney general or any Department of Justice in New Hampshire in their right mind would go after us the way California did, considering we had the resources and gumption to take them all the way to the U.S. Supreme Court. Of course, if you were a smaller nonprofit and the idea of a $20,000 or $50,000 legal bill came up, that could have devastating impacts to your small nonprofit. So this legislation would simply make sure that would never happen, and no New Hampshire charity would end up going through what we go through, or what we went through for 6 years. So that's what we want to forestall here. And I know the Philanthropy Roundtable is doing these efforts nationally, and I think it's important work. I think there's a few things to keep in mind. We mentioned RSA 664. I will say that in New Hampshire under 664, if you are engaged in any electioneering, you have to file a political committee, whether you're a nonprofit or any other entity. Americans for Prosperity files as a political committee, and any other nonprofit has to. That would not change at all under this legislation. They would still have to file with the Secretary of State's office. One last point I'd like to make to the committee is just, as I said, the impact that this would have on think about the local smaller nonprofits. They don't have the resources to go and go to court and protect their constitutional rights. So I think it's important to understand, putting that hat on from my perspective, of how, if we had got a demand letter from the Department of Justice, how we would handle that. Obviously, we'd have to go find legal counsel and pay them. And again, the idea of a substantial legal bill could have a major impact on a small nonprofit here in New Hampshire. Ultimately, they probably would just comply. In other words, they just give away their constitutional rights because they don't have the resources to defend themselves. And that, to me, is particularly concerning. So with that, I'll end my testimony. I'd be happy to take any questions from the committee.
Questions for Mr. Moore? Representative Macbeth.
Thank you, Mr. Chair, and thank you for taking my question. I'm not familiar with the case now, the NAACP, the 1958 case that we've heard referenced, or actually with the case in California. But in 1958, in the CP, I mean, my gut response, thought you said, is that they didn't want to reveal their donors because they probably thought they would be killed. They weren't chilling effect on donors. So you had said that they didn't want to give it out for the chilling effect on donors. I'm just wondering, with your familiarity, is that the reason?
I'm 100% convinced that that's true, that you're right, that the health and safety of their donors would be a top priority as well. But beyond that, there would be a chilling effect for future donors. I'll tell you, in the process of doing fundraising, have to admit, when you work for a politically active nonprofit, a lot of your donors ask if their contribution will be kept private. It's because while they might believe in that, they don't want their name associated because they might be in business doing something else and it would have a negative impact. And frankly, the top reason, I think, is that they're afraid of further unwanted contributions. In other words, if you show up on a list as a donor to one organization, there'll be a conga line of fundraisers from every other organization that will line right up and start soliciting you as well. And if you've ever hung out with some larger donors who are known to give contributions, donor fatigue isn't just being tired of giving money. Sometimes it's just tired of being asked for money. I hope that's helpful.
Representative DiLorenzo.
Thank you, Mr. Chair, and thank you, Mr. Moore, for taking my questions. I noticed that you sent around a handout, but there are no citations, no references. I mean, what is this?
So that is a list of the organizations that filed amici briefs before the Supreme Court. The case was Americans for Prosperity Foundation versus Bonta. And Bonta is the Attorney General for the state of California.
May I follow up, please? And what was the date on that?
So the case itself was argued early in the 21 Supreme Court season, and it came out in June of 2021.
Thank you.
Thank you.
Other questions? Representative Simpson.
Thank you, Mr. Chair. Thank you for taking my question, Mr. Moore. This that you just handed to us. So I guess I'm thinking through the difference between keeping board members' names private and keeping donors' names private. And I'm wondering, this list about your case in California, was that specifically about donors or was that also about board members?
So the initial demand on the part of the California Department of Justice was for donors. It did not involve so the Americans Prosperity Foundation is a corporation that's based in Delaware, so it's a Delaware-based corporation. So it would follow Delaware law as far as reporting, and then obviously it would be considered a foreign corporation in the other states in which it operates. But to your question, it was just the demand was just for donors.
Okay, great, thank you. And then, oh, sorry, can I follow up?
You may.
Thank you. I'm thinking about donors to nonprofits and how, like, the AG's responsibility to protect the public. And my thinking is that a lot of donors want transparency about who's making decisions about the budget and about where the money that they're giving is going. So I'm wondering in the course of this, like how you would talk about balancing those interests.
Again, that's a great question because I come at it from a number of different angles. I will say that in my donor meetings for raising money for Americans for Prosperity, Americans for Prosperity Foundation, I get asked a lot of questions, and we go through the entire process with our prospective donors. That's obviously for larger donors, and not so much for the person you're doing a mail solicitation for $25 is obviously a little bit different standard. But if you're asking someone for a six-figure gift, you're going to get asked a lot of questions. Some of those presentations literally will be like 4 or 5 hours. And I will say that donors ask those questions, and at the first instance, I think it's might be selling the donors a little short as far as asking those questions, saying that you need to have the Department of Justice oversee that. I understand the Department of Justice perception. I certainly get the fact why they would like to have access to more information. But again, having that access to the information, how that information can be used, it could potentially show up somewhere else if that information came to the Department of Justice. It could be subject perhaps to a 91A request, and then suddenly all that becomes public via that route. So I mean, there are ways of once that information is transferred, for it to become public in a way that could be damaging to the individuals involved.
Can I? Thank
Yeah,
you.
sure, certainly.
I'm trying to think through now, like one more step, which is like, so all the 501(c)s are exempt from taxation on this money. So it seems to me that the 501(c)s then have a responsibility, like a greater responsibility to the public to show what public good they're doing and how. Then I don't know. I'm just, you know what I'm trying to say is like, what's the balance that you
I
see
do,
there?
and of course there are a ton of charitable nonprofits that do incredible work, and it's also important to understand it. And I understand this from the Department of Justice standpoint of there are scam nonprofits, right? There are groups out there that just basically set up a shell and put together a couple nice glossy flyers, and maybe they have a really charismatic person. And at the first instance, though, I would say that it's the responsibility of the donor to be able to work through that. I mean, I large donors ask so many questions. They do, and I think it's probably because they have been solicited by some of these potential scam nonprofits. But the risk of subjecting all the good nonprofits to potential harm, that obviously you're the legislature. You make that public policy decision. But I would say that the protection offered to the nonprofits doing great work every day is outweighs the harm.
Representative Smith.
Thank you, Mr. Chair. Good afternoon, Ms. Moore. You just said something that made my mind take a leap to FRM, in which ultimately the state was held responsible because it did not catch the fact that there was some inappropriate conduct going on. My mind connected the two because if the state is responsible for verifying eligibility under 501c, for getting reports, et cetera, if in fact there is an organization that is not using donated money in a way that is appropriate, and if the state has no way of knowing that, nonetheless, wouldn't the state be responsible as it was determined in the FRM case?
You raise a great point, Representative. I think that potentially by injecting the state into this, there is a liability risk for the state that they're taking on, as we now see, as the past budget showed, where the settlement funds are, some settlement funds are in the budget. I would also say this: it's important to understand that the nonprofit world doesn't operate in a vacuum. There are a number of organizations that review nonprofits, GuideStar and other organizations that actually go and they review it. And if they find, for example, that a nonprofit is giving away a relatively small amount of the funds that they raise, and I've seen nonprofits that they give away like 10 or 15% of the funds that they raise, and the rest all goes to overhead and organization, they get downgraded. And when those organizations like GuideStar downgrade a nonprofit, it becomes a lot harder for them to raise money, and appropriately so. I know that's not quite appropriate; it just came to my head. So I thought, but I wanted to add that. But I think you raise a great point, Representative.
Other questions? Seeing none, thank you for your testimony.
Thank you.
today. Alyssa Margolin.
Mr. Chairman, members of the committee, good afternoon. My name is Alyssa Margolin. I know I've addressed this committee several times about housing issues. I'm here today with a different hat on. I'm here as a public policy consultant with the New Hampshire Center for Nonprofits. Our CEO, Kathleen Reardon, couldn't be here today, so I'll be providing her testimony. The New Hampshire Center for Nonprofits is opposed to Senate Bill 302. The center is our umbrella organization in the state. We have 700 members. The entity is dedicated to strengthening and giving voice to the nonprofit sector through leadership, collaboration, and learning opportunities. Overall, we oppose this legislation because we believe there are a number of unintended consequences to these proposals. As has been mentioned, this is the source of this proposal is really a national effort around donor privacy. And we really think that this proposal is in search of a problem that does not exist in the Granite State. So I'm going to talk a little bit about that. First, I want to raise an issue around the role that was mentioned earlier about preserving the public trust. Over the last couple years of pandemic-related challenges, I think it's clear to all of us about the important role that nonprofits play in your community. Our sector in the state often plays the role that government would play in another state. It's really important that our nonprofit sector in New Hampshire know how to effectively manage finances, engage in transparency around governance, avoid self-dealing, and remain politically nonpartisan. The new layer of proposed restraints on public agencies and right to know public bodies regarding the records of nonprofits could erode our public trust here in the granite state. Of course, we do value our rights of privacy, and we talk a lot about privacy in the boardroom. But we think here we have appropriate transparency that ultimately create an agreement between our donors, our volunteers, and our leaders, and the nonprofit sector, and help us being more successful at executing on our missions. Another likely adverse consequence to additional confidentiality is what anything would happen when you have like just a lack of transparency, a lack of sunshine. In these highly divisive times, there are few societal spaces now that are nonpartisan. We at the center encourage advocacy, and we honor, but we do think it's important that C3s remember that they can't endorse candidates nor give money for public office. But there is a growing amount of pressure to move money through the C3 sector, and something that we're watching and concerned with. And in the last administration, there was an effort to repeal the Johnson Amendment that would have allowed more political money to move through the nonprofit sector that we work to oppose. We also, as noted earlier by the Charitable Trust Unit, our DOJ here in the state does not ask for a donor list. They never have, and this is already settled law in the Bonta decision that's been mentioned. Overall, we do find this unnecessary and potentially harmful. We do appreciate there was some efforts to amend the legislation in the Senate, but we don't think it went far enough. It's still a head scratcher for many of our members. Things that have come up: can we publicly thank volunteers? Can we publicly thank donors? I mean, we know that that's kind of the bread and butter of a lot of nonprofits, right? Is the list and the you're in this club and that club. And we also know that so many of our nonprofits honor anonymity regularly for donors who request it. What about the administrative burdens of compulsory confidentiality? What does that look like? And what happens if they make an error and have inadvertent disclosures? This was not a concern raised inside the state by the nonprofit sector, and seems to go further than needed. This is New Hampshire. We need to be accountable to one another, and so we urge your committee to find the proposal inexpedient to legislate.
Representative Simpson.
Thank you. Thank you for this, and thank you for taking my question. I actually had a question about the penalty section, and so I'm glad that you raised it. We haven't talked really about it yet, but I wonder if your organization had a response specifically to the dollar amounts and the penalties, or how that would work, or did you talk about that more?
I don't think I'm prepared to talk specifically about the penalties in the proposal, but just to say it's, as we talked about, this kind of scrappy nature of a lot of our community organizations, that they're so impactful. You know, any kind of additional administrative burdens, could be a concern. And obviously, if there are penalties associated with that, that could have a real adverse consequence on a smaller nonprofit. There are also issues around, there's some safety issues that have come up, like what if there's a question about a coach and some background that a coach, and what if a parent makes an inquiry, and just we'd be tying the hands of a system that seems to be working for us right now.
Representative Macbeth.
Thank you, Chair Gordon, and thank you for taking my question. So out of your 700 members or whatever, have you, and I know times are different, but have you noticed any of this donor fatigue, or is there a drop off in, donor participation or contribution?
Well, so New Hampshire Gives is right around the corner, and last year was the most successful New Hampshire Gives we've ever had. Granite Staters have been very generous in response to the pandemic. And I think our government leaders as well, in terms of making sure resources could get to the nonprofits. The nonprofit emergency relief program that came out of the CARES Act money, we were the first state in the country to make sure that we were bolstering nonprofits. And philanthropy, I think, generally has increased in the state. On national basis, our numbers look lower than other states, but that could be because of the way it's counted and connected to religious organizations because we have fewer of them in this state.
Thank you. Thank you.
Representative Horgan?
So I've noticed these philanthropic organizations, they often advertise, if you look at their websites, they frequently talk about all the other philanthropic organizations that they're associated with. So they're not necessarily, I mean, some people do make anonymous donations, but they're not necessarily secretive about who they're working with when it comes to talking to potential donors. But it seems like this would shut government agencies, including law enforcement and also, government agencies that are subcontracting with these organizations. So it seems like this would shut off a lot of oversight without restricting their ability to use their affiliations to promote themselves to the potential donors or other groups they want to partner with.
Thank you for the question, Representative. As the Charitable Trust Unit noted earlier, identifying scamming, is really important in the nonprofit sector. So if you are a veritable nonprofit doing good, say around breast cancer, I know in my community we have a great organization called Breast Cancer Stories. And another entity that comes in and is fraudulently securing funds from your community, that's less for you. So it's a partnership that we have with government to make sure, and the public interest to make sure that we're holding up the organizations that are doing things the right way.
Okay, thanks.
Other questions? Seeing none, thank you so much. And is there anyone else who hasn't testified who wishes to testify? Yes, sir.
Good afternoon, Mr. Chairman, members of the committee. I apologize for not putting in a testimony request. My name is John Conforti. I represent the New Hampshire Lottery, and I will be brief. The New Hampshire Lottery Commission oversees charitable gaming in the state, games of chance, bingo, lucky 7. And we're not taking a position on this bill, but we did want to identify that there are elements of Senate Bill 302 which are in conflict with some of the current statutes relating to bingo, lucky 7, and games of chance. I doubt that bingo was top of mind when this legislation was drafted. So we wanted to just make a note of the fact that as regulators of that entity, we do request during the application process and during our financial reviews who is involved in the charity with these games. In the case of bingo and lucky 7, the charities themselves actually operate the games. And therefore, we do require oversight to know who those members are that are participating. And so there are a number of statutes, 287D6, 287D22, 287E5, E7, E9, E21, and E24, all of which would be impacted by Senate Bill 302, would restrict our ability to identify and be able to license charities for that gaming activity. This is obviously all voluntary activity on behalf of the charity, that they come to us seeking a license. We do not go out to them, but we would encourage you to consider, if this legislation is moving forward, consider an exemption for those statutes that are currently in place, which allow us to license those charities for charitable gaming. Be happy to take any questions.
Representative Wolper.
Thank you, Mr. Chairman. Thank you for taking my question. Can you give us that list? I mean,
I can, and I can also submit it afterwards if that would be easier.
whichever way it works.
Okay.
Right? I just want to get it.
I think just to be on the safe side, I can submit that to you and the chair after this hearing.
That'd be super. If you send it to us in an email, we'll distribute it to the committee.
Excellent. Thank you.
Representative Smith.
Thank you, Mr. Chair. Thank you very much. Can you tell me why, given the strength of your testimony, which seems to me to be rather important, Nonetheless, you're not taking a position on the bill?
It's our position as an agency not to take a position on the overall bill. And again, we just wanted to make note that there's a technical issue between standing law right now and the bill. As an agency, we try not to take positions on bills. We just try to educate to tell you what the impact would be for our agency.
May follow
Thank
up.
you.
Representative Horgan.
Yes, when I heard the words trust and lottery in the same paragraph, I immediately thought of the device to set up a trust to receive the winnings of your lottery ticket. But I guess that would normally not be a charitable trust, although I suppose it could be if that's what the winner wanted to do. So is there anything in that bill which would interfere with that practice, which many jackpot winners choose to take advantage of?
It should not, because as you identify, that is those are not 501c trusts or charitable organizations that claim those tickets. We have had charities where we've had people who have donated the tickets to charities and they come forward, but they're also more than happy to publicize that they've won Powerball or Mega Millions, and we're very happy to provide them with that check.
Right, thanks.
Representative Chase, did you have a question?
Thank you. Thanks for taking my question. I'm just looking at the report from the Senate. Did you bring these up in front of the Senate, and what did they say?
We did not, Representative Chase. We were not advised of the bill, and we were not aware of the bill as it went through the Senate. The Department of Justice made us aware of the bill's presence during at the end of the Senate process after it had already passed through. So we did not have an opportunity, or we missed on the opportunity to identify these issues for the Senate. So that is ultimately our responsibility. We were not aware of it.
Other questions? Would you fill out a pink card and submit it to us?
I will. Thank you.
I want to make sure we spell your name right.
Yes.
Thank you.
Thank you.
Is anybody else who wishes to testify? There was a request to have, Representative Macbeth, you asked if you could ask another question of Ms. Quinlan, is that correct?
I did. I wanted to know, the historic nature of this, it was brought up before, the tax relief that donors get. Historically, was that kind of why they got the tax release? I mean, could you tell us a little bit about that?
Sure. That's
And how much is it? I don't know. Is it dollar per dollar? Or?
Well, one of the reasons that the public first of all, charities serve public purposes, and that's why they're provided with a tax exemption in federal income tax and oftentimes property taxes. So it's because they serve that public purpose that they get those exemptions. And so as a result, there has to be some oversight and some transparency.
Okay.
So, okay. Thank you. I'll follow up.
Thank
there.
you,
Thanks.
Ms. Quinlan.
Thank you.
Any other any other people wishing to testify? Seeing none, we will close the hearing on Senate Bill 302. And our committee will be in recess until next Wednesday, the 13th at 9 o'clock. Not a problem.
Thank you for indulging.
And I actually spelled it right before you did. Thanks.
So I did send you a text, but we'll talk tomorrow. All right. Long day.